Yep. So apparently, the judge hasn't started her deal yet. Judge has not started her deal yet. We're back. I'm back. I don't think the judge has started her deal yet. So I'm going to Fulton County Superior. She turns it on when she comes into the courtroom. But the Fulton County Superior, which has a worse feed than the Zoom call. Let's see if she comes in here. She turns her camera on when she sits down, when she settles in. I'll share with you what I'm doing here so you all know what's happening. Share. I'm not late. I'm just on time. Judge Krause. Let's go. Waiting for Judge Krause. I didn't share it with you here. But this is what we're doing. Why this jump there? Scheduled for January 31st? No, what the hell is that? That's not right. Let's go. Why is it going to that? Precisely. I'm not the leader. La 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 la. This is her live. Maybe when it refreshes, we'll see it. This was what ended. This is not live. This is what ended before when we all wrapped up. But you see, this new stream only was created when she turned her camera on. It wasn't here a minute beforehand. She just turns her camera on, all of a sudden it's live. No. And when I press on this thing, when I go to the Superior Court Judge Codes, I have to go to our partner site. And I press let's go, and I end up on this thing saying waiting for Judge Krause. But it says scheduled for January 31st, 2022, which I don't know what the hell that means. That's not what it should be saying. That's what has me concerned. So you think I'm in the right place? It's just this placeholder? Could be. It was the smartest move. It was a very short lunch break she gave us. It was the smartest move in the world that I made to break. I took care of my prayers, got some food, got my coffee. Feeling much more refreshed. So I have 3,000 fewer people watching me now. That's okay. They'll come back. They'll find their way. Okay. Not really liking how she's so late. You made us all rush back, honey. Waiting for Judge Krause. Nothing. I go to the link that I had here. Let me see what this was the link that Ashley gave us. This was for this morning. Let's check this. It's the same thing. That's the link she gave. Let me press live. It has this thing. Why wouldn't it show here? Normally in the lives, you should see upcoming here. Like next to this over here. This should be slid over to this one position. This should be like upcoming. That's what I think it's supposed to be doing. So that's what's making me suspect. That's what's making me suspect that when I come to this Fulton Court Superior Live, when I come to this live proceedings thing here, and I come down to Judge Krause, and now hit the let's go, that's what makes me suspect that this is crap. First of all, there's only 4 people waiting here, which it shouldn't be. There would be a lot more. Second of all, not like thousands, but 100. Second of all, if that's what was really was upcoming, it would be here, I think. I have dark mode on certain things and not on other things. I actually thought I had YouTube on dark mode. Dark mode is not good on everything. I'm using dark mode on StreamYard, and I'm like, it's very hard for me to see stuff. Atlanta News first. Let's try that. Thank you.
Okay, so Judge, just this 4 o'clock is coming up now. We were asked before the break to take witnesses out of order because Ms. Miller needs to leave by 4, and we agreed to take them out of order to accommodate that. But if everybody is to leave by 4, then we would prefer not to take them out of order. We were doing that to accommodate her, but she needs to leave by 4. But if we have to end at 4 anyway, then we can take them in the order that we wanted.
Okay.
If that makes sense.
I feel like that makes good sense if we're going to need to end by 4 anyway, to let the plaintiff call whatever witness they want to, since if we haven't reached Ms. Miller yet, everybody will be leaving at 4, and then we can reconvene tomorrow, and hopefully we're not going to have the conversation about when and how that will be until and unless we need to. Okay.
And Judge, just we will be here tomorrow. I have an appointment a doctor's appointment in medical.
They have to do the Zoom thing. I don't like the audio here.
We'll continue if we're in the middle of a witness. I just wanted to let the court know that.
Thank you.
We will try to not break a witness up or anything like that. If we did not plan on tomorrow, we will definitely accommodate. But I
completely understand, and I hope that all of that is an only what if and doesn't actually come to fruition anyway. So let's go ahead and get started.
Great. Okay, so we would call Dexter Bond into the stand, and we would invoke the rule of sequestration.
Okay. So the rule of sequestration has been invoked. That means that anyone who is expected to be called on as a witness, I see.
I don't think it's the right link.
That Ms. Miller is stepping outside.
And Judge, I think makes things faster. County.
Got it.
County that in some of our conversations about that they may be willing to stipulate that our open records.
And it's just started.
And that they were not responding
a minute ago.
3 days, according to statute. If that's the case, I can remove a lot of my questions. But if the court wants that testimony, then I think the question is when they were complied with, but I don't think anybody's arguing they were complied with in 3 days. So if that's the case, I can remove a lot of my questions.
Ms. Monroe or Mr. Bowman, who am I going to hear from relative to this witness?
From me. So what I did say that I was going to stipulate to is that the information wasn't provided initially, but as far as the 3-day window, I would have to double check because there are several requests before Your Honor. So I'd have to double check which ones in fact were not responded to within 3 days. So I can't make that confirmation. If I just have like 2 minutes to check my notes to see which ones were actually
I think that is time well spent because that 2 minutes might save us 30 minutes. So if you will take a moment to do that, that would be much appreciated, Ms. Monroe.
Thank you.
And regarding as a moment ago, I was talking about the rule of sequestration. Just right now, it looks like we're only going to be having Mr. Bond and Ms. Miller as an initial matter, but I just always ask, y'all know who your witnesses are and what they look like way better than I do. So if somebody wanders in, please keep an eye out. also that applies, I'm sure I don't need to say this, but it bears repeating to anybody that might be watching on the Zoom or on the live stream. If you anticipate that you might be called as a witness in this matter, you should not be observing these proceedings. Thank you.
I don't anticipate that I'll be called. Very unlikely. It's like really unlikely I'll be called. Like less than a 1% chance. Now, I will have a Chiron running across, which will have the name of the witness, whose witness it is, whether it's direct or cross, and what their title is. So, like this, I'm ready to start to prepare. This is direct testimony of plaintiff's witness. I don't remember the guy's first name, something Bond, and I don't know his title. But you should look for that Chiron so that way you're not confused as to that way it just answers a common question. If you walk out and come back in and you're not sure who's on the stand, whose witnesses is direct or cross, I try to keep that updated fairly regularly to make it easier for those essential what's going on questions to be answered without me disrupting the flow. That looks like Mr. Bond, I assume. So, Mr. Bond, we meet again.
I'll give you the same spiel. So be careful of the ledge to your left there, because that chair is on wheels, and I have actually had a witness take a tumble, and I don't want that to happen to you.
I think he's a
Perfect.
clerk.
Let me
this
be
guy.
number 2. I appreciate it. Thank you, Your Honor.
Swear him in. What are we waiting for? The district attorneys haven't showed up yet? No, they're there. That's Monroe. What are we waiting for? Maybe for the court reporter. They could be waiting for the court reporter. She's the only one we don't see right now.
I'll tell you what, since Ms. Monroe, since Mr. Bond is here, if you'll continue to keep looking, but also let Ms. Monroe see if she can at least start with some of the preliminaries. And it may be that even I'm sorry, Ms. Merchant, it may be even that Mr. Bond can confirm what you're trying to confirm. I appreciate the effort, but just in the interest of time.
Yeah, of course.
Mr. Bond,
Yes.
if you'll do me a favor and raise your right hand, I'll swear you in. Do you swear the testimony that you're about to give the court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, thank you, sir. You may lower your hand. Now, if you would, for the record, state and spell.
I'm not doing the controlling the feed.
There's musical accompaniment.
She's looking.
I thought it was the document too.
See.
Oh my gosh.
Why is there audio?
Okay, so I think you already, or I was asking you to please state and spell your name for the record, and then I will deliver it over to Ms. Merchant to begin her questioning.
My name is Dexter Q Bond Jr. BEXTER, middle initial Q. Bond. I am a junior.
Great, thank you so much.
He is a junior.
Can you tell us what your job title is?
I am the Deputy of Operations for the Office of Fulton County District Attorney's Office.
Does that include being the records custodian?
Yes, among many things.
And before we get into the documents, I want to talk to you a little bit about the portal, how that's set up. If first, let's talk about at the time that I made the request in January of 2024, was there a website link on the DA's website
for open records at that point in time?
In January, yes, there was a link on our website. Yes.
And when a person clicked on the link on your website, it took them to the county attorney's open records portal, correct?
Yes.
And there was a drop-down box if they went to that open records portal to request records from the district attorney's office?
And I can't speak to that because I
Okay.
don't request records from the district attorney's office.
So at some point in time from then till now, was that landing page from the DA's office website removed?
I don't have information to that. I don't know.
Do you know if the open records page, the page that the public would go to, if that link was ever altered?
Are we talking from, give me a time frame.
From January until now. So what we just talked about was in January. If I went into the DA's office website, I clicked on open records, it took me to the portal.
Yes.
A month ago, if I went on the DA's website, clicked, and there was no open records link at that
I
point.
cannot speak to that. I do not monitor that site on a daily basis. I do a lot of things for the office, but that is not one.
Okay, so you cannot speak to whether or not there was an open records portal site or portal link on the DA's website.
No, I answered that question. There is an open records link on the DA's website. You will click the link. You can go into the portal. You can request open records requests as you do often.
So there was one in January and there is one now, right?
To my knowledge, yes.
Do you know if it was removed at any time over the last 9 months? And
I cannot speak to that.
thank you. Who could?
I don't know. I don't maintain that particular website. Once the information is placed in the portal, if necessary, it'll be elevated to me. And I do my job as the business records custodian. But as it relates to it sounds like, forgive me if I'm wrong, but I'm interpreting your question to be a little bit more, I don't know what you're asking me, but I can't.
How the public asks you for open records.
And I'm saying that the DA's office has a website. As you know, the DA office has a link that you can use. The DA's has once you click that link, it goes to a portal, which we have used several times. And once you go to the portal, you can put in your request. That's what I'm saying.
Are you able to testify if over the last 10 months that process has been in place?
I don't object just based on the fact that the availability of the link in the portal is not an issue in this case, and it's not an issue pertinent to whether the records were provided timely.
Yeah, I don't know where she's going with this either.
Ms. Merchant, is there a reason, is what you're really trying to get to that for the entirety of the last 10 months, Mr. Bond or someone else would be tasked with and subject to complying with open records? Or are you really trying to ask if there's an actual portal button on that website for the whole last 10 months?
I'm trying to figure out if they've had, so once I made my request in January, I had to make follow-up requests and it went away. And I wasn't able to continue to make those follow-up requests, which is
Okay.
part of what, when we continue
I
to
understand the question.
make those requests.
Okay.
Forgive me, I'm gonna reframe your question and you make sure that I'm not reframing it appropriately, right? Your time frame at issue is from January to the present.
Yes.
And you are asking me at any time, did that particular process deviate?
Yes.
The answer is yes.
Okay.
May I explain?
Why
Please.
be a dick?
Because of the cyber attack. I do know, if I'm familiar, that you received the open records request saying that, hey, we are under a cyber attack. This will require a delay. And I do know that this portal is not maintained by my particular office, right? I think you and I can agree with that they made some modifications. So if your question is, look at 10 months, did something change from the routine? The answer is yes. The reason why is because it was a cyber attack.
And I'm just going to interject very briefly. You're like me, you're naturally a fast talker. And for the benefit of the court reporter, she's already asked us once to slow down. So
Okay.
if you'll try to be real conscious about speaking slowly so she can take it down. Okay.
Yes, Your Honor.
Thank you, sir. Go ahead, Ms. Merchant.
And I just want to make sure I understand. So it changed because of the cyber attack. So that portal link was at some point disabled or not available?
So you asked me, did something change? I reframed the question to make sure that we were on the same page, right? I told you, yes, something did change. I gave you an answer as to why that did change, and that was as it relates to the cyber attack. Again, The framing of your question was from January to the present for the last 10 months, right? And enter in your question, you asked me something about the last 10 days. So forgive me if
10 months, I'm sorry.
you said 10 months, but you also said 10 days. I asked you a follow-up as it relates to the framing, right? I've answered that question from January to the present. I have told you that the reason why that has changed is because of the cyber attack. I've
Don't ask
also
why.
told you that I do not maintain that website on a daily basis.
My question was, how has it changed? You said it's changed. My question is, how has it changed?
In what
I
way?
cannot answer that question. What I can say is that from 2021 to the present, the DA's office has had access that allow constituents like yourself to request open records. That link is displayed on our website. Once you click that link, you can go into the county's portal. I've also told you that I do not monitor that website on a daily basis. So if you're asking me how, I cannot answer that question. But if you telling me to look at the last 10 months, if it has changed, I am telling you a cyber attack has required a lot of things, including open records, to change.
This is what the Zoom call is
Um,
showing. I'm giving
Do
you
you
the
monitor
feed
the
from
open
the
records
court.
portal?
Do I monitor it on a daily basis? No.
Do you monitor it at all?
Yes.
How often do you monitor it?
On an as needed basis.
As needed.
Yes.
How do requests come to you?
You go to the link, you put it in, it goes into the portal.
Sorry, and just to save time, I'm not asking how I do it. I'm asking how they come to you.
Once a staff member on my staff, a designated staff member for open records requests, receive the open records. If it's standard, like the many of you have supplied, we can go ahead and give you a responsive record, right?
Tell they hate
If it's not
hate
standard and it requires an elevation of some sort, then it is elevated to me by a staff member.
Elevated to you? by staff?
Elevated to me by
Okay.
a staff member.
So the first sort of triage is the staff member reviews it, determines if they can just answer it quickly.
I would say that, yes.
And then if it's something that's more elevated, can you describe what something more elevated would be?
I'll do it the opposite way if I can.
Yeah, that's
If
the
you're
way to
looking
do it.
for an invoice, a particular invoice, and that invoice has been commonly requested, my staff knows that this is a particular invoice. And for efficiency purposes, we'll get that responsive document to you as quickly as possible. And then if you're talking about something that is exempt or possibly exempt, that's an example of something that's going to be elevated. And not in this particular case, but in some cases, my exemptions include open and active investigations. So in those particular cases, that'll be elevated.
Were my requests elevated?
You have to be more specific. You know, you gave me about 40.
Were any of my requests elevated?
Yes, ma'am.
Were any of my requests not elevated? You can narrow it down.
I'm going to say yes because 40 was not presented to me. I know that you are a frequent open records requester. I know that we have responded to open records requests. I am familiar that you, I would say dozens. And I would not say that
They're
all
not showing
dozens
it.
have been
This is
presented
the
to
Zoom
me.
court feed.
Those have been closed out.
They don't
based on my
show it when they
monitoring.
have a
So I
document
am
up.
comfortable saying that all have not been elevated to me.
And you said I did 40 open records requests?
I said dozens, maybe 40. I feel comfortable saying dozens. I know,
They're maintained on the open records portal, right?
yes, I'm pretty sure they are.
No, I
So
can't.
maybe 40, maybe 30, but I know it's a lot.
Would it surprise you that it was less than 12?
Oh yeah, I think I'll be surprised by that.
Okay, and let's go through them in a minute. We'll go through the specifics. But
May I ask a follow-up? 12 an issue or 12 a total?
in total,
Since when? January to the present?
since Ms. Willis was DA.
That would surprise me. That would surprise me.
There's a very big difference between 12 and 40.
You all have a employee manual that you use at your office, right?
Yes,
Okay, and that governs, it also talks about open records requests.
I believe so. Yes.
And if you want to look, we've got, these have been admitted previously. This is merchant 0602. I believe the county attorney supplied this, I'm assuming from your office. Does that look like, you can look at it on your screen, part of the employee handbook that's given to new hires that Ms. Willis created? or updated?
Mr. Bond's eyes may be better than mine, but you might need to make it bigger
Okay,
because my screen's pretty small and I'm
yeah, it's
struggling.
hard to read.
So that's okay. Thank you.
Thanks. Does that look like the section regarding open records compliance?
Yes, at first glance, yes, 6.6, Open Records Act compliance.
Okay. And it says that all open records requests submitted by members of the public will be handled by the open records officer. Is that you?
It will be handled through the portal, so no, not necessary. It will be handled under my leadership.
Okay. And so handled under your leadership, but through the portal. It also says that DA employees should consider all communications that occur on county email, cell phones, and other county-owned technology to be considered open to a FOIA request.
Subject to no exemptions, yes. So I think that's consistent with the Open Record Act. I would
Okay.
agree with you.
Okay, so subject to no exemptions, county email and cell phone communications would be something that you would provide in open records.
General rule, but I think you and I can agree certain things exception. I work with 385 staff members. Of those 385, about 150 or so
Okay.
are attorneys, and we know that there's exemptions. So anything that they're working on as it relates to attorney work product or confidentiality work product are exempt. So yes, this is the general rule, but I don't want the general rule to be mistaken as the norm.
Right, I understand, definitely, there's statutory exemptions.
You and I are on the same page.
The statute's the
And to be
statute.
clear, the employee handbook, while it is helpful guidance, doesn't change what the statutory obligation is one way or the other. So
No, it just, and the reason I'm asking him is the process in their office. You're trying to understand this process.
And if I can clarify, I think the second sentence is certainly important, right? I know that our employees, again, I alluded to the size of the office, 385 approximately. We want to make sure that staff members who receive open records requests know what to do with it. So that I think that was the angle.
Okay, so the employees receive this and they are told that they need to forward it to legal counsel of the district attorney when they get something.
At the time of that writing, yes, legal counsel.
Okay, this is the current handbook though, right?
Mm.
I'll represent it's the one that your office provided earlier this week through Ms. Monroe.
I would say yes. If your representation is correct, I would take that as this is the current one.
And legal counsel, right now it's Ms. Abbasi, I don't want to say her name wrong.
Alibi.
Alabi, Miss Alabi is legal counsel now. It was Mr. Armstrong before, correct?
Yes, he was at one point.
Okay, so according to this, Mr. Armstrong or Miss Alabi would be copied on all open records requests received by employees?
So no, let me deviate. The answer to that is no. The reason why is we had several different legal counsels since 2021, and based on their strengths, weaknesses, or expertise would determine whether or not legal counsel will handle that. So I had legal counsel before. That was his expertise. He felt comfortable handling it. I cannot say if Kevin Armstrong handled open records. So I want to be clear. As it relates to Andrea Alibi, a dynamic attorney, however, open records is not something that she handles.
So if a member of the public was reading this and at the time they made their request, Kevin Armstrong was legal counsel, it'd be reasonable for them to think that Kevin Armstrong would be apprised of their open records requests. Assuming this is followed.
No,
No.
I don't think so.
Okay. This also, let's see if we go down a little bit more, it talks about emails. Let's see, email communications. This advises employees that emails are monitored, and essentially that means that you're telling them you have access to emails, or the office has access to emails, correct?
You have to tell me the line. The way that I read that is my district attorney, FANI T. Willis, requires us to look at emails. So 3 times a day is our standard.
If you look under section 6.9, the third line, it says to ensure compliance with this policy, computer and email usage may be monitored. Does that mean that the district attorney's office can monitor computers and emails?
Not necessarily, well, can we? Yes.
Can, that was the question. just-
Yes.
Okay, so you have access to emails,
Yes. I do
Okay.
have some. Let's
You
be
have-
clear.
some,
Some emails, yes.
access to county files. On county computers or county phones.
Yes.
So on a county computer file email system, you've got access to emails.
When you say you.
Your office, I'm sorry.
Okay.
I mean, when I say you, it's been represented and we can pick a term if you want, but as that you're the man for open records. You're in
Okay.
charge of all of this.
It
So,
definitely seems
So
like
the answer to your question is, as in you, as in Dexter, right? Yes, I will have access to that.
okay.
Or I will request access. Is that better?
Yes.
Okay.
And so this also, if you look at, let's see, after where it says only those who are directly supervised by the district attorney can send emails directly to her. So is that the policy, that someone who's not supervised by her is not permitted to send emails directly to her?
We have a strict chain of command, so I think that is true.
Okay, so it's reasonable then for a member of the public who is trying to seek emails to assume that emails would go through a supervisor before they went to the district attorney.
That'll be a general practice. I think so.
As an open records custodian, part of your job is to be familiar with the rules with record retention, right?
Yes, to a degree.
Okay, and so you've got to, and that's actually in the, if you look on the same page, if you go up a little bit, there's a policy for record retention and it says that all records are maintained in compliance with the state of Georgia's retention schedule. Would you agree with that as the policy of your office?
That is the policy.
So any records that the public is trying to access, they can assume based on the policy of the office that you're going to retain them based on the state of Georgia's retention policies.
That is an accurate assumption based on this policy.
While we're on this document, if you flip to the next page, 0603, it talks about county cell phone policy. It says that all investigators and attorneys are required to have a county cell phone and that text messages, recordings, and photos within that cell phone are the property of the county. So that means that if someone did an open records request for those types of documents, that's in the county's property, right?
This is what get hairy. As it relates to Fulton County's property, the answer is yes.
So it says they're required to have a county cell phone. So an attorney is required to have a county cell phone. Let's use an example. Jeff DeSantis is required to have a cell phone, county cell phone, correct?
He doesn't work as an attorney in my office. If we're going through your analogy, give me an attorney. I can't speak for Jeff.
And I'm looking, it just says all investigators and attorneys.
And Jeff isn't an attorney.
He's not an attorney?
I don't, in the capacity of my office, no, he doesn't act as an attorney.
So
ADA, yes, is required to have a cell phone. An investigator.
are you, Jeff DeSantis doesn't have a county cell
No, I'm not saying that. You presented the analogy that all investigators and attorneys are. I understood your analogy. You gave an example of Jeff DeSantis. If your analogy is investigators and attorneys, I want to keep you honest. And I'm letting you know
Keep
that
you
in the
honest.
capacity of Jeff
Why don't you
DeSantis, he
start
doesn't
trying to
fall in either category. So I'm following you
Please do.
and I offered you an opportunity to present someone else. And I gave you an idea of an ADA because the ADA fits with your example.
Let's back up for a second.
Okay.
Jeff DeSantis, and I was just using him as a apparently unfortunate example. He is the deputy district attorney, correct? That's his job title.
His working title in the office is public relations.
he's a deputy district attorney. That's what he's hired to do. Jesus.
Sure.
Thanks. Showing you a printout of the district attorney's website. So take a look at that and see if that refreshes your memory as to what Jeff DeSantis' official title is within your office.
Deputy district attorney
Thank you.
overseeing the media relations unit.
Who cares? He's a deputy district attorney.
So
all
the
attorneys.
policy
Jeez.
that we're looking at, county cell phone, says all investigators and attorneys are required to have a county cell phone. You're saying that not all attorneys and investigators are required to have a county cell phone. Is that accurate?
That's not what I'm saying.
Then what the
You
hell
gave an
are
example of Jeff
Jeez, what
DeSantis. I
Jack,
could not speak specifically as it relates to Jeff DeSantis. I'm not arguing whether or not this policy exists. All investigators and attorneys are required to have a cell phone.
Okay.
That is correct.
Okay, so all unnamed attorney has a cell phone. According to this policy, if that unnamed attorney on their county cell phone is messaging on an app on their county cell phone, and they're recording things, and they're taking photos, screenshots from an app, that's subject to the open records request.
If there's no exceptions, yes.
If there's no exceptions, thank you. Okay, let's move on to one of the requests that I want to talk about, and I have a couple different identifiers if you need them, but it's the critical mention media monitor. Oh, do you know if Jeff DeSantis has a county cell phone?
No, I do not know that.
You do not know that. Okay. Who would know that? I'm assuming him. Anyone else?
I don't know.
All right, so let's move on to critical mention media monitoring. If you
He thinks he's winning here, but the district attorney doesn't want Jeff DeSantis to have to take the stand. And all he's basically doing is he's proving we need Jeff DeSantis on the stand. You don't know if he has a cell phone? All right, well, let's go ask him. This is like when you're like outsmarting yourself. He thinks he's very clever. And then he's like, no, you see, you're saying this. He's not an attorney. He's public relations. And even blah, 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 blah. All you're doing is you're just confirming to the judge, I guess we need to hear from Jeff DeSantis. Does he have a phone?
need me to tell you the request, the open records number request, or our exhibits or anything, I'm happy to do that. Just let me know, okay?
Okay.
But I'm going to globally refer to them as critical mention media monitoring.
Okay, I'm gonna stop you here.
Mhm.
I know that we have a lot of critical mentions, so I would prefer for the clarity of this court to make sure that we're specific on critical mention, because I know there's multiple.
Not a problem.
So
There are
don't-
two.
So my ask is don't globally refer to them as critical mention, if that's
will
okay
not.
with you. Okay,
Can you pull up merchant 0027, please? There are two requests. This one, just for your clarification, ends in 010924. This is my first open records request. On January 9th, I requested any and all correspondence, as you can see, to or from critical mention, including copies of contracts, payments, analytics, reports to or from critical mention and any member of the district attorney's office. Would you agree this request is pretty clear and concise?
based on my reading, yes.
And I submitted it through the Fulton County Open Records portal,
January 9th, yes.
and it was received January 9th. It says, if you scroll down a little, it shows it was received that day. That's when they return it with the reference number, that is saying that it was received.
That is correct.
Can you repeat what page you were referencing,
I'm
Ms. Merchant?
so sorry. Yes, it is a merchant 0027.
Thank you.
And it acknowledges receipt of the open records request, correct?
On January 9th, I received that via the portal. We acknowledge receipt because you have a reference number. The answer is yes.
Okay. It doesn't say anything about whether responsive records exist.
Not on January 9th. That's the day I received it.
Doesn't say anything about proposed costs or when the records will be made available.
On January 9th, when I accepted it,
Mhm.
no, I think that you have requested several open records requests. You have given them, you've been given all the records, right, that we closed out free of charge. So there is not anything that from my office that would have a cost, because I did not charge you on any open records request that you provided.
I didn't ask that. I asked if it provided any proposed costs. Does this provide any proposed costs?
On January 9th response,
This document,
this document that you put before me, January 9th, I acknowledge that it is a receipt number for tracking purposes. It is a acknowledgement of receipt, and is a description of the records you requested.
great. If you would scroll up, so on January 12th, someone wrote back, or I wrote, thank you, and I followed up saying I was asking for the analytics,
Point.
the contract, and the analytical reports. And I was asking, following up, when I could receive them.
3 days later, yes, it appears, I don't know, Ashley Merchant wrote, thank you, in follow-up. I also asked for, yes.
And then on January 11th, someone, either from your office or the county, said, please log into the portal and see attached emails, correct?
January 18th.
January 18th, I'm sorry, if I said a different date.
So January 18th,
Mhm.
Based on this email,
Okay.
we gave you attached emails, and included in those emails, there were several different documents. So yes, I responded to this open records request on January 18th.
Did you type this or did someone else? Please
I did
log
not.
into the portal.
I did not type that.
The attached emails, did you provide those attached emails?
No, I did not.
Who provided those attached emails?
A member of my staff.
Who?
A member of my staff. I do not know who provided that on January 18th, but I do know that this particular request, as you said, was Pretty straightforward. So we responded and it was closed out. This wasn't elevated to me.
So you never saw this request? You were not involved in this request at all?
On this particular request based on the portal, I don't recall this being elevated to me on January 18th. No.
So you can't tell us what searches you performed looking for these documents?
I can tell you that.
You can.
Yes, this was a general request. It wasn't elevated to me. Critical mention.
I did nothing.
It's something that was always asked. I have several requests that's very similar to this. So I'm pretty sure not this particular one, but one of critical mention was elevated to me, and we responded the same way we did with most critical mention.
Who did you ask?
I'm sorry.
Who did you ask in response? You said you did ask somebody about these records. Who did you ask?
So with critical mention, you ask, based on this search, you will look and you will reach out to Jeff DeSantis.
Oh.
Hey, do you have any emails related to critical mention? After that, you will go to the IT department to confirm,
Okay,
see
so
if there are any responsive records.
Fulton County IT Department.
Yes,
Okay, so Jeff DeSantis and Fulton County IT are the two. Okay.
especially when you ask it for emails, the answer is yes.
But you don't know if you did that in this case.
I know that I did that in critical mention. I have 1,000 cases. So as it relates to this specific request, I cannot tell you that this particular case was elevated and this was on the top of my list.
And once someone makes a request like this, what steps do you take to ensure that the documents they're requesting are preserved?
Repeat that?
When someone makes a records request like this, as an example, what steps do you take as the records custodian to ensure that the documents they're requesting are preserved?
They are placed in a portal. Once the portal is sent to you, I think that you have access to that. And I think that that is something that the portal does and make sure that it is reserved. And I can have a copy if I needed to go back to those specific documents. So as it relates to you, this is when you and I are going to make sure we're not splitting the baby. But as it relates to the portal, they are reserved.
Okay. And we'll use this as an example and sort of walk through the request. So once you get a request like this, whether it's elevated or not, what are the steps your office takes to make sure that the documents I'm requesting aren't destroyed?
Typically, once documents that you're requested are placed in a portal, the portal, right, will maintain those particular documents, right? You have an email version, electronic file of those versions. So that's in the portal. So
So, and maybe I wasn't clear. So you're telling me how you maintain the documents you give me. What I'm asking you is when I ask for critical mention documents here, okay? And you get this request and you give me some of them. How do you make sure that they're all maintained? So you all maintain them? I'm
gonna answer your question, but I'm gonna make an assumption if I may, okay? I made a comment and I said that there was 40 open records requests. You looked and it appeared, assumption, emphasis on assumption that you was gonna go see how many open records requests you had, right?
It's all there.
Yeah. So the answer to your question is it's in the portal, it's all there.
No, that's why I didn't know if you understood my question. My question is not.
I
how
just
you
repeated
preserve
you.
Hang on, don't talk over each other because the court reporter can't take it down.
My apologies.
That's okay. Ask your question and then
Jesus.
you are free to respond in any way you wish.
I'm not asking how you preserve what you tell me you have. What I'm asking is how you preserve the documents inside of your office that I request, not the ones you give me, but the ones I've asked for.
If you ask for 5 invoices, right? I'll take those 5 invoices. Those 5 invoices is giving to a staff member to provide to you. So the original copy of those invoices maintain wherever they are, right? You have a copy that's filed electronically, right? It is given into the portal. So if I understand your question correctly, 5 invoices. The 5 of those invoices are sent to someone on my staff. A copy of those invoices are uploaded to the portal. Those 5 invoices, the original copies, wherever you came from, continue to stay there. Did I answer your question?
Yes. So
Okay.
the originals continue to remain wherever they originally were.
It depends on the particular document. If you, in my example, I gave you invoices.
Right.
We do know that invoices are electronic, right? Well, I like to think that most invoices are electronic. So in those particular invoices, wherever they are on my particular file, they stay. A copy is employed to my staff member and then uploaded to the portal.
And let's go through some specific things that you gave me, and then we can sort of go back to that question because it might help.
Yeah.
If you look, let's see, if you can pull up merchant 0029, on January 18th, there was, let's see. I received this packet that we talked about of emails uploaded to the portal. What you're looking at is the beginning of that packet, and it was 44 pages. That was in response to my original request discussing critical mention. You said you did not produce this document, correct?
No,
Down
I
a little
don't
on
believe
this
so.
one. See
Did
where
you
it's
assist
after
in
Melissa
retrieving
puts-
these
It says,
For these particular documents,
PR,
no. These documents.
Fonnie Willis critical mention search. It's a different font, and then PR value for the week, and then there's a couple other things. This, and we now know, because we have the actual emails, we now know this is 4 or 5 different emails that were pieced together. Did you participate in the cutting and pasting of these documents?
Thank you.
Objection, Your
I
Honor.
don't-
Objection, Your Honor, presumes that he cut and paste documents, and that was never established by his testimony, so we're objecting to that.
Okay, well, for now, I'm gonna sustain your objection to the characterization of the cutting and pasting. But you can certainly ask him if he participated in the creation or generation of this document that was produced to you, however it came to exist. So your objection is sustained to that extent, Ms. Monroe.
And Judge, I thought that was Mr. Bowman's witness. I might be mistaken, but I prefer not to tag him.
Well, I do agree. I apologize. Who is going to be examining this witness?
I would,
Oh, okay, well then, fair enough.
I didn't know that was a thing.
Well,
I mean,
Mr.
generally-
Bowman had objected, so.
Yeah, generally speaking, you know, whoever's going to be examining the witness is the one who should be controlling the objections. And I think Ms. Merchant's expressed concern was she thought Mr. Bowman was going to question this witness, which would make your objection
Weird.
problematic. But since you're going to be examining the witness, it's fine.
That's fine.
I'll frame for Your Honor.
Usually I just ask that you whisper in your partner's ear so they can then say the thing that you want them to say.
And I showed Mr. Bowman the documents because he had made the first objection, so I just was assuming that was the path, but I will check. Okay, so this document, however it was created, did you assist in the creation of this page?
No, I think you and I agree that the first request was straightforward. I don't think that this was elevated to me. And on January 18th, no, it was not elevated to me.
Who compiled the document in the form that we see it in here today?
A member of my staff. That's an assumption. A member of my staff.
Okay, so you're assuming, but you don't know who compiled this?
Specifically,
Yes.
on January 18th, yes, this is a designated employee, yes.
You're positive it's a designated employee?
Well, okay. Yes, I'm positive I know who that is.
Who is it?
Erica Willingham.
Erica Willingham. So Erica Willingham is who we would need to ask, not you as the records custodian, about how this document was created.
I cannot answer that question. Let me explain why, right? Typically, emails are compiled in a certain kind of way, right? And those emails are compiled by IT, by staff. It may be compiled by going to reach out to various different persons. I cannot speak to that. So I cannot tell you if she personally, if the question was, did she compile? I do not know. I do know that she handled it as a member of my staff. I do know that she responded as a member of my staff. I can tell you that.
So you can't say as the records custodian that this is an accurate copy of an original document. Let's put it that way. You really don't know anything about this document.
I do know something. I know it was responsive to your request. So yes, I know something. I think you and I can agree on that.
Let's take a look
This is
at,
a
I'm gonna
difficult
jump
dude.
out of order, I apologize. If you, let's see.
I also know, if I may, that it was provided to you on January 18th. I also know that you received this
I'm
particular
using that
document.
link. I switched over because I saw the rant.
I also know
I didn't read it
that
out
you
loud.
mentioned that there was
I
a
just
second
did it.
critical mention document And in that second critical mention, I know you referenced this before, right? I also know that once you referenced this before, you renewed a second critical mention document saying, hey, you gave me this on January 18th, I'm looking for A,
Yes.
right?
And we're gonna
And
get there.
that's why you and I on the same page, didn't want it to be global. So I do know information as it relates to this particular request.
And we can actually go there right now. So I filed a second request because my initial request was closed when you all provided this 44-page document, right?
Yes, on January 18th, it was close.
And so on January 18th, I refiled my request and I specifically referenced the original one and said, why are you closing this? You didn't give me everything. Did you?
If I can,
Yes,
I like the fact that you presented the first one and allowed me to read it. Can I read the second one?
of course it is. Let's see. I don't have the number off. The second one is.
I feel like I know way too many people who work for the Fulton County District Attorney's Office. I know way too many people who work.
There we go.
I don't mean personally. I mean, I've seen too many of them on TV by now.
So this one I said in regards to my prior request, and I referenced that number we just talked about, and I said I requested the critical mention documents, and I say the number. I said I got a set of emails, but I asked for the analytics and the documents that are clearly referenced and attached to those emails. I said reports with analytics were provided to the DA's office monthly. It appears from the emails that Jeff DeSantis, Connie Willis, Jeremy Murray, Pallavi Perkasa, Robin Bryant, and Rita Kepler may all have access to these reports on a regular basis. They're public media, paid for by public funds and subject to open records.
Yes, I did receive that. This was elevated to me, and I did respond to you.
Okay, so this one was elevated to you, and you definitely did respond. Before we get there, let's talk about what we were just talking about a minute ago about the I don't want to use the word cut and paste, the document, and I'm going to call it Merchant 55, that appears to have a compilation of several other emails contained within it. Okay, that document we were looking at a minute before, and you said you don't know who prepared that document, right?
I do not know who compiled that. I know who handled the file. I know who sent you the responsive document.
And you don't know where that person got the responsive documents, but you assume it was Jeff DeSantis, is what you said earlier.
I did not say that, ma'am.
You said you would reach out to Jeff DeSantis in Fulton County IT.
But he certainly wouldn't compile any documents for me.
Oh, okay.
Okay.
So who would compile them? Who would, and let's just look then. So you've seen, and can you show him again, Merchant 0055, just take a look at this document, because I'm gonna ask you to compare it to a different one.
Okay.
So just to make sure I'm clear, I thought that Mr. Bond said that he believed that Erica Willingham was the person who compiled the response at Merchant 0055.
I thought he said that she did, but that she would reach out to Jeff DeSantis and the county. First, he said he didn't know who provided it. He said that they would reach out to Jeff DeSantis and Fulton County IT.
Well,
And then later,
that's actually why I'm asking for clarification, to make sure we're all having the same conversation, because I understood you to be asking him about who compiled the document that was provided to you, not who obtained the information that was then determined to be responsive and compiled into a document that was provided to you. What I understood Mr. Bond to be saying was, this type of request, I would have reached out to DeSantis and maybe County IT, and then it was compiled by this particular employee and provided to you.
okay. And I'm not sure. That's the ultimate question. So let me try and be a little more
Just
clear.
ask him.
This document, number 55, okay? It looks as though it's a compilation of other emails, okay? If you look after Melissa Frick's name, it says FANI Willis critical mention search, and then PR value for last week, and then there's that middle section that we're talking about, middle section right here. There's no header to from or dates here. There's no header to from dates here. There's no header to from dates there. That, they all look like different emails, right?
I would agree with you.
Okay, so not using the word cut and paste, someone took these parts.
That's what she's
put them all in
saying.
one.
Edited.
Objection, Your Honor. Is that a question, is a statement? I mean, if it's a question to
Well,
the,
he's an adverse witness, so she can cross-examine if she wants to, number one. Number two, I mean, the reason I said we were not gonna call it cut and paste is that assumes facts that are not yet in evidence. Now, you can ask questions about assumptions that you're drawing from the appearance of the document, But that's why I've said we're not gonna call it a cut and paste. Now, I think the witnesses called it a compilation, so why don't we call it that for a while until we decide that it's something else?
So this appears to be a compilation of several different emails into one.
I don't think
I
she's
agree.
helping him.
Yes.
Okay.
I think she's acting in good faith.
Continue. We're here to learn from you, tell us. What were you gonna say?
No, I'm agreeing with you. That does appear to be a compilation of emails.
Okay. And can you pull up merchant 0167?
So there's cutting and pasting. Get him to say it, Ashley.
So
And how does that happen?
there's a
By cutting and
redacted section
pasting.
here, and then you can see under that, I sent a story via critical mention a few minutes ago, directly below. Okay? So this, and this were removed from that email. It just starts with I sent a story via critical mention. All of that is not in that compilation document, right?
As it relates to the headers.
As it relates to the, I'm sorry?
Yes.
Yes.
It does not appear to be so.
So this was all removed. And the document just starts right there.
I cannot tell you if it was removed. I think my testimony, Your Honor, is that this particular request came in January 8th, right? We responded on January 9th. On January 18th, we responded to the documents, right? Once we responded to the documents, you accepted it. What I need you to hear is we closed that particular file. It was not elevated to me. Your second one was elevated to me. Let's call that critical mention 2, if I may. That critical mention 2 referenced the first critical mention, right? In that critical mention 2 that you just displayed to me, it had only one specific item. I am looking for analytical graphs. I responded to that request. So as it relates to anything that from the first time I gave it to you, it was responsive because this is me as the business record custodian. Once I received the second critical mention reference that referred to the first, you and I can agree that the first had, let's just say, 5 things. You only made mention of one thing in the second one. I assumed 1, 2, 3, 4 was resolved, that is closed. And I responded on January 26th to the remaining issue. So as it relates to compilation, I want to be very clear. It was sent to you. It was responsive to your request. I moved on. You referenced it. Once you referenced it, it was elevated to me. The elevation was one specific item. So I assumed that the first matter was resolved and the only outstanding issue related was analytical drafts embedded into something, which I responded to you on January 26th. Is that clear?
No.
Okay.
And so let me break it up because there was a lot. So I tried to take notes. First, you said I accepted it. So on January, whatever the date was, 18th, I accepted it. When you said I accepted it, you sent me a document and I accessed it and it was immediately closed. So you're saying that's an acceptance of the open records response?
I am saying that we sent you the open records response that's responsive to your request.
Yes.
All right. I am also saying that you opened up another open records request. In your second open records request, that's why it's very important we do not refer to this as globally. You make reference to the first.
Yes.
You said here in court that the first one was very detailed, in which I agree. Okay? I let you know that I did not have anything to do with that. You gave responsive records. Once you respond to me in reference to the first one, and there is one thing outside, I am a reasonable person, that's the word that you use, will assume that the first is over. It's done. It's complete. So I am assuming, reasonable or not, that you accepted the open records request because you said, here's a second one. I did this, I'm referencing that, and here's a small section.
So you assumed I accepted it and.
It was delivered.
Hold on.
Is that better?
Deliberate.
It was sent to you on January 18th.
Yes.
Y'all, there is no reason to argue about the semantics of what we're talking about. It is not in dispute that on the whatever day it is
January
that
18th.
the Open Records Act portal sent you a batch of documents. And then I don't think it's in dispute that that request was closed, and then you followed up on it, which the county or the Fulton County, whatever we're gonna call it, treated as a new request that referenced a prior request. We don't have to argue about whether it was accepted or received or acknowledged or whatever. The facts are what happened. Let's move on.
So you said that that was responsive to my request, but it didn't completely respond. It only partially responded to my request, the first one. The 44 pages weren't all that you had.
Objection, Your Honor, is that a question or a statement?
It's a question. The 44
Okay,
pages.
hang on. When there's an objection, let me deal with it. We're just gonna put a question mark on the end of Ms. Merchant's statements because technically that's what they are, but they are allowable cross-examination questions, so.
Right, but I want to put the witness in the best position to.
Now, this is direct testimony, and what the point is, she's asking leading questions. But you're allowed to ask leading questions when the person is deemed hostile. If it's a representative in a civil case, if you call up a defendant or representative of the defendant, they're automatically assumed to be a hostile witness. Because they're automatically assumed to be a hostile witness, even though it's your witness and it's technically direct, you're allowed to ask leading questions. There's a good lawyer-teacher moment. That's why I paused.
Answer the question, so if it's not posed in the form of a question, I think that's, the onus is on her to pose it in the form of a question as opposed to a statement.
I think that right now I'm gonna, unless I believe that
This is
it's
why.
being deliberately confusing, which so far it is not, I'm going to allow Ms. Merchant to question the witness. And I'm gonna overrule your objection for now. Go ahead.
Thank you.
You have to repeat your question, I'm sorry.
By the way, this is why I was saying that Ashley Merchant is a great attorney in certain respects. Her questioning of witnesses is one area I've seen from her, which is like it's a little bit. It's not as strong. It's just not as strong. The way she's framing her questions, it's not really a question. And I understand we all know what she's saying, but it's not nearly as clean compared to the high yardstick she sets for herself as an aggressive bulldog in going after things.
The 44 pages that you sent me on January 18th, you said that they were responsive to my request, but they were not complete. There were additional documents. Now we have 197 pages. So the 44 were only partially responsive. Is that correct?
Okay, I have issue with your question, so let me break that down, okay? As it relates to you, I have testified that on January 18th, a member of my staff responded to you and provided you responsive documents, okay? So you as in Dexter Bond did not give you anything, okay, on January 18th. The responsive request for your records that sought 5 things were given to you on January 18th. The answer is yes. On the next day, as you just testified, a new open request was opened. You made reference to the first request, right? Of that, again, the first request was 5 things. You only asked about one thing. The first one was never elevated to me, okay? The second one I responded to on January 26th.
Okay. So my question, didn't answer my question. The 44 pages that you provided, your office provided.
Her husband sitting
January
next to her
18th. That is not all the documents.
They're partners
that
in
were
a law
responsive
firm.
To the original request. It was only partially what was responsive. Correct.
At the time on January 19th, I couldn't answer that question. I don't know. I don't know.
So you gave me documents, or your office gave me documents, and then you have now certified 10 days ago that 197 pages are the actual.
2 different things.
Yes.
So I'm glad that we was able
And
to talk.
hold on. So now we've got 197 documents.
Okay.
Back then we had 44.
Let me,
Okay, hold on. Those 197 page documents, those existed in January when I made my request, correct?
I cannot say that.
You don't know if they existed?
May I respond?
If you answer my question first, I'm happy to allow you however much time you want to respond.
Okay.
Did those documents exist in January? The 197 pages? Your business record certificate?
I cannot answer that question. May I explain?
Why you can't answer it?
No, let me explain why I cannot answer it. That's correct. Let me explain. your open records request that you presented asks for certain things, right? I'm assuming that you are talking about the production of the documents that you gave on August 30th, right?
Yes.
All right. And you, in that production document, I'm assuming you're saying that that was 197. What I am saying that I cannot correspond, because it's my assertion that the open records request that you received on January 18th is different in scope from the subpoena you requested. And because there is a difference in scope, because your subpoena was more specific, I cannot tell you if the two are correlated. So I cannot answer your question.
So you can't tell me if the 197 pages that you provided on August 30th, if those existed in January?
That's not what he said.
Yes, they would have existed. The 197 pages should have existed. However, I cannot tell you, let me be very clear, that the 197 pages that you received on August 30th as a response to your subpoena was responsive and should have been included in the 44. I'm afraid that you are looking at an open records request that you received on January 18th, accepted with no reservation. You're convoluting a subpoena. There's two different scopes. There's two different, your search terms were different. So yes, the 197 did exist in January 18th because the scope in which you asked for was from January 2021 to the present, whenever the subpoena came in, right? We did that through IT. Those documents you could certify. I cannot tell you if those 197 were responsive to the 44 because your open records requests and your subpoena are different. Your subpoena is more specific.
Okay, so my open records, my first one said that I was seeking a copy of any and all correspondence to or from critical mention, copies of contracts, payments, analytics, and reports, okay? So correspondence, that's emails.
One.
Correspondence is emails.
And I gave you emails.
The 44 pages versus the 197 pages. Would you agree with me that there are a lot of emails in the 197 pages that were not contained in the 44 pages? A lot of emails. We can go through them page by page if you'd like.
If that's what you prefer.
It is not. It is
Okay.
definitely not.
What I am telling you, and I need to be very clear, that your subpoena that produced 197 pages, right? It required, look at this particular email to and from, right? As it relates to these particular search terms. So your subpoena was filled out and given to the Fulton County IT department, and those 197 pages were given, researched, and provided. Let's look back at your open records request. There were no search terms. If I am not mistaken, and you may have to bring it up to reflect my memory, you just wanted something about to and from the vendor or something like that. There are two different things, two different scope. So if you're making an inference of 44 versus 197, I cannot buy into that inference because I see logically why 197 and 44 could be different.
And I'm trying to break it down simply so that we can just get through one item at a time. My original open records request, we're only talking about correspondence. You and I agree correspondence includes emails, correct?
I agree.
Okay. And would you agree that the 44 pages did not contain a lot of emails that the 197 contained?
I can concede that.
Okay. The next classification is contracts. Okay. So I asked for contracts between the DA and critical mention. Okay. Would you concede that the contracts I got in the 44 pages with my open records request did not contain all of the contracts I got in the 197 pages? Would you concede that?
No, I cannot concede that. You have to show me that.
Okay, that's not a problem.
You
Which
have to
one?
show me that.
So we'll break it down even further. In the 44 pages, the original request, you only gave me a contract for the first year of critical mention, correct?
Show me.
Okay, let's see. Okay, the 44 pages start at, just so everyone knows, they start at merchant 0027. And that one may take a few more minutes to get up.
And basically what he's saying is you
Oh,
made
yeah,
two different
0027.
requests, got two different responses. And she's saying, no, my first
And if you
response
want a hard copy of
sucked.
the documents, I can give you that as well. Okay,
Because
in
you left
response to
stuff
that,
out.
if you go through the next couple of pages, is it easy to pull up the next couple of pages? Yeah, let me give you the exact page. It's actually the next page, 0028. And I didn't have that one queued up, but we'll have it in a minute, sorry. Or I can just show you.
That is what he meant.
It's 0028.
No mandatory pages. Definitely. Definitely.
February,
I love it.
2021 contracts for critical mission. Oh, there they are. They're up.
I'm glad you said that. I'm glad you showed me this isn't a contract.
No, this is not. This is part of it, and if you go through.
You and I just had a conversation about emails. I conceded. Now you're talking about contracts. I told you to show me. Now you show me an invoice. Which is it? Do you have a contract?
Judge, I mean, I don't care if he asks me questions, but I don't really think it's appropriate if he asks me questions.
Well, I'm not, you're not obligated to answer the questions he asks you. I would just encourage everybody to try and maintain,
Decorum.
you know, a tone of civility and let's move on.
Yes, Your Honor.
So, we'll back up. The
All right. The
44
second one
pages.
was subpoena, I believe.
I'm gonna give you the 44 pages. Okay? So you can just look at those. We don't have to go.
Are you gonna point out the contract in 44?
Give me 1 second.
Oh, okay.
Okay.
I'm sorry.
So my open records request to you asked for contracts. Okay? That was one of the classifications we just talked about, right?
Yes.
Are
Okay.
there any contracts there? What pages are
Show
they?
me where in there you gave me contracts.
There you go.
I don't believe it's in here. You could not show me, so do you want me to go page by page? Because you said that
Yes.
you was gonna show me,
I want
You
you
gave
to
me-
tell
Oh, Jesus. What a dick.
right? And then I said, all right, the 44, so now I can go through here to determine a contract. So you put, I'll do it.
So
Oh,
You said that you
right,
was gonna
so-
show me.
I'm gonna show you the one you gave me,
Okay, no.
but that's in the second
You were
request.
talking in the context of these 44 pages.
Oh, my
You
God.
told this court
He's being
that I
such
gave you
a
a contract.
jerk.
I said, show me. You approached me with the invoice.
You gave me
I
that
told
invoice.
you-
Okay, stop,
Stop.
both of you.
Stop.
The question I think is pending that will actually help us move forward is that Ms. Merchant asked if any contracts were produced in the original 44-page production.
Yes.
And while none of us will necessarily enjoy that endeavor, it is perfectly fair for a witness to say, let me review the 44 pages and then I'll answer your question. So
Right.
if you would like to do that,
It
you
should
feel
take-
free to do
It
that.
should take a minute and
But
a
the
half.
question is,
You go page by
was
page.
a contract produced in the
Boom,
initial
boom,
production
boom,
of 44 pages? Because I think we had agreed that contracts were requested.
Yes.
Go ahead. Mr. Bond, if you want to go through the documents, or if you want Ms. Merchant to direct your attention to something, we can do that, but
No, tell him to go through
44
it.
pages
Tell
is
him to just
entirely
go
fair
through
for
it.
you to say.
It
"Let me
takes
look
a
at these
minute and a
documents, I'll answer your
half.
question."
Yes, I would like for you to direct my attention as you said you could.
I'm asking you to answer the question the judge just asked you that I originally asked you. That I asked you.
This is
if
so
you gave me a
childish.
contract.
Go through the
And
damn
we
44
agreed that
pages.
I asked for a contract, okay? So we agreed I asked for a contract. I want you to show me where you gave me a contract. Or if you didn't, tell me you didn't.
Okay, allow me to review.
Great.
He didn't send the contract. We all know this. That's what I said. Look, he's already like 7 pages in the first 12 seconds. There's no contract here. I told you it'll take less than 90 seconds. I'll just take turn the page. Contract sticks out. Jeez. There's no contract here.
Based on what you presented to me, assuming that there are 44 pages here, no, a contract is not in this.
Thank you.
In the
Took all
197
14
page
seconds.
document that has your sworn certificate on it, did you provide me with a contract?
I don't know.
May you direct me to that contract?
I'll give you the whole 197 pages. It's your sworn business record certificate that you swore to the court was accurate and complete. Give me a moment to reorder that.
I would love to see this contract that she signed. The contract she's referring to, in case you missed this morning, is a contract that Fannie Willis the county paid money to a company to monitor
On the screen or
Fannie Willis's PR. That was a Fulton County expense. So she wants to see that contract.
May I approach, Judge?
Yes, and you don't have to ask every time.
Thank you.
On the renewal of work, just that.
Miss Merchant, I'm sorry, I can't hear you when you step away from the podium very well.
That's the
Sorry,
court
thank you for
reporter
reminding
talking.
me of that.
She's like, I gotta get this stuff down that you children are arguing about.
The renewal statement of work, if this is in my file, here you are, but this is a contract.
It is. Okay, so
What I just showed you was the contract, one of the contracts for critical mention, correct?
You showed me a renewal statement of work.
And that was not provided in January of 2024, correct?
It does not appear to be so.
Why not?
I'm gonna show you another, I'm sorry,
And if I can, before I know you're about to move on,
Or not?
we agree, right, that there were some emails, right? We also, as it relates to the contract, you said that you that there was some documents in that particular file that you have in the 197, okay? You also can agree, I hope, that on the second open records request, you brought forth, that was elevated to me, hey, Dexter Bond, I'm only missing with the analytical. So you and I can agree that any contract or anything was not in your any open records request. We can agree to that?
No, we cannot. Can you pull up Merchant 0055, please? Oh, I'm sorry, wrong one. We just had it up. I'm sorry, 0008.
No, that would not surprise me at all. That would be a nice little aha. But a lot of this back and forth would be avoided if she was asking questions, just shorter questions, just tighter. Part of this whole massive exchange is because
I'm seeking a copy of
questioning
any
is-
and all, including copies of all contracts.
everywhere.
That is my original request.
Yes, but you and I, you received this on January 18th. Yes. On January 19th, you said, you referenced this same open records request, right? And you said, I am only looking for, I received your request, you acknowledge receipt. I am looking for the analytics inside that.
I'm not talking about that yet, and we're gonna be here all day if we go and talk off track.
The first open records request, this one, first one, I asked for contracts, okay?
I just showed you a contract that you gave me on August 30th. That contract was not provided in response to this open records request. Not a follow-up, in response to this open records request, correct?
The answer is yes, that contract was not provided in January 18th.
Why not?
There's a contract for critical mention for 2021 to 2022. You take a look at that.
Yes,
That contract was provided August 30th, but was not provided in response to my open records request,
this
correct?
statement of work appears to be provided in August 30th.
I mean, you certified the documents that you provided August 30th. Do you have any question about them?
No, I certified the documents on August 30th, but what I need to be clear is once the matter on January
Let
18th
us
was
be
not
clear.
elevated to me. I think that we're clear on that. When it came to January 26th, you requested 5 things. There was one thing in your second open records request that you brought to my attention. That was elevated to me. I assumed that on the 44 pages, everything else was responsive because you do a good job when you don't get something, bringing it to our attention. We do a good job of responding to you. So yes, you asked for 5 things on January 18th. We were not, my staff gave you 44 pages. When you brought forth the second critical mention open records request, of those 5 things, you brought forth 1. That one thing was elevated to me. So we make mistakes. If I did not give you a contract on January 18th, I would have loved, as I often hear from you, to get, hey, you're missing this, just like you did on the critical mention analytics graph. You did not bring that up.
Judge, this is not responsive to my questions. I mean, at all, not even close to responsive.
I generally try to let the witness answer the way that the witness wants to answer. I will, however, say that I think we are getting bogged down in what previously did or didn't happen based on people's characterizations and understandings rather than, and I think one thing that would help, Ms. Merchant, is if you would ask short, clear,
What did I just say?
direct, factually based, and not argumentative
Yes.
questions.
It-
And then Mr. Bond will do his best to give short, concise, factually based responses that are not argumentative. Because I understand that both of you have a position that you wish to vindicate about what you did or what you think did or did not happen here, but we need to set that aside. Go ahead, Ms. Merchant.
Just asking you about my first request. We're on to the third category, payments. I asked for payments.
It's not losing her
How
touch.
critical
It's that
mention
this
was
is not her
paid,
specialty.
correct?
Questioning witnesses is not her specialty.
You asked for contracts in or payments, on January 18th.
In this open records response, did you give me payments for critical mention?
I gave you 44 documents that I believe was completely responsive to your request.
Mr. Bond, you did not give me a copy of the payments for critical mention.
And when I reviewed the 44, I did not see a payment.
And you also did not give me any analytics, correct? In response to this one, just this one.
On January 18th, no, I do not believe. When you say analytics, I don't even know what you're talking about. Are you talking about the graphs that's embedded in the critical mention? I don't know what you mean by analytics. Let me make sure I'm clear.
The critical mention analytics reports.
The same analytics reports that you asked for in the second critical mention request?
Only asking you about the first one.
So no, the
No.
answer is no.
Okay.
Not in January
Did
18th.
you give me any of the critical mention reports in response to this request?
The answer is no.
Okay. So the 5 categories, correspondence emails, contracts, payments, analytics, and reports. You did not give me any of those 5.
I gave you 44 pages.
So now we'll move to the second request. So when I got those
She finally got there, but the point is, I sent you 44 pages that are worthless crap. That's essentially what she just got him to admit. I sent you 44 pages of worthless crap, but even that she needs to nail down. So you sent me 44 pages, but none of them were remotely related to the 5 things I asked for.
44 pages and was not happy with the response, I filed a follow-up open records request. Would you agree with that?
Hang on, Ms. Merchant, to my point about argumentative, right? This is further complicated by the fact that you're also your own witness. And so your questions are not only tending to be argumentative, but filled with facts that haven't been established yet. So
Okay, and that was
work on that.
And I was drawing from what he had said about me.
Then reference the document. I think that'll be a cleaner way to keep the record clear. That way we know it's a fact that's in the record.
That same day, January 18th, now I'm talking about that second open records request. I followed up and asked for more documents, correct?
Yes or
I'm just
no?
asking if I followed up and asked for more documents.
Yes or no? Yes or no?
May I answer this question this way?
No.
You
No.
pointed out
It's a
the
yes
5
or no.
categories. Thank you for doing that.
Oh,
okay?
Jesus.
In your second open records request, you asked for not more, the same documents in one. To me, that was interpreted as you have satisfied my open records request, so I cannot say if you was unhappy. However, of those 5 things,
That was not the question.
there's one thing in here that you're missing.
This is
Can you respond to
reeling
that
your
one
witness.
thing?
F you, shut up, yes or no? Did I ask for more documents?
So let's talk about that second open records request.
Jesus.
So I submitted another open records request and asked for more items, correct?
You asked on that second open records request for the analytics graphs. That was also asked for in the first open records request.
And was not provided in the first open records request.
It was not provided, well, based on my review today, no, it was not provided.
And it was also not provided in response to the second open records request.
So on the second one, a response was provided via the Open Records Act. That response on January 26th, footnote 1 reads, no, on January 26th, I don't know what subsection said, essentially, forgive me legal terms, I don't know what you're talking about.
Your response, your ask is not reasonably calculated to put me, the business record custodian, in a position to know what you're talking about. At that time, I did not know what analytics graphs were. I didn't know what you were talking about. So you can reference my letter, which I addressed this second open records request personally because it was elevated to me.
I will in a minute, but let me re-ask my question.
Okay.
Did you provide me any analytics in response to my second open records request?
I provided you a response.
Did you?
In my
provide me-
response,
Hang on.
there was,
Hang on. She's asked you a yes or no question. I think you can answer it and then explain.
yes, ma'am.
Thank you.
No, I did not give you any documents. I did give you a response. That response said, pursuant to OCGA, Open Records Act, that it is not, your request, as stated, is not reasonably calculated to put me in a position to know what you are talking about.
On January 24th, I sent your office a letter talking about this open records request again, the critical mention, media monitoring data. And that's at Merchant 0083. If you want to take a look at it, we'll have it up in a minute. Do you recall receiving that letter?
I recall receiving a letter from you, but I do know that that letter was not exclusively for critical mention.
That's correct.
Okay.
That's
just
not my
making sure.
question. My question is, do you recall receiving that letter?
Yes.
Great. So let's look at what section of it talks about critical mention. Okay. I was following up, and this was asking to please not have to go into a lawsuit, right? That's what this letter was.
I don't know what this letter was, but I do recall seeing it. I don't know if it was a please not going into this lawsuit.
So it was entitled Numerous Outstanding Open Records Requests and Notice of Potential Official Complaint and Potential Civil Action. Do you recall that?
I don't recall the title, but I do recall receiving the letter.
Okay. And you recall generally the contents of the letter?
Yes.
And specifically, let's talk about the critical mention. I asked, and this is on Merchant 0083, I outlined again what I had been asking for, and provided even more context in regards to these emails, analytics, things like that. Do you remember receiving this?
I do.
Okay. And you responded, and this would be Merchant 0087 if you want to pull that up. This is the letter you referenced earlier. So this is the letter you're saying is from you, correct?
Yes.
It's not signed and it doesn't have your name on it, but you're saying that this is your letter.
Yes.
You drafted this letter?
Yes.
And
What
the
was the page number of that? I'm sorry.
sorry, it's Merchant 0087
Thank you.
through 88. The only name on this letter is FANI, correct?
You have to show me that.
At the top. There you go. At the top.
Is the only name on this letter FANI Books?
Are you referring to the letterhead?
I'm referring to someone who received this letter would think it came from.
Okay, well, I'm going to stop you there because that calls for speculation. But if you could go to the bottom of the document, maybe we could see who signed it. Thank you.
And we just talked about nobody signed it. On the next page, 88, you know that you did not sign it, correct?
Go to
I'll
88.
have to see the second page.
Yeah.
You can pull up the next page, it's 88 here.
I believe it was the Open Records Unit or Division or Open Records, sincerely Open Records.
Okay.
So did I sign it? No. But did I draft it? Yes. Is it from my team? Yes.
Looking at these two pages, the only name from your office, someone reading this would see. is
Who
FANI
cares?
Books, correct?
I don't know what we're getting at from here.
You would see the only name in her letterhead. Yes. It's any correspondence, I believe, that comes from the portal on any letter is going to have her letterhead on it.
Every letter from the DA's office has
The
that.
question is just, that's the only name that's on that document.
But it says it was sincerely Open Records. He's saying that's a signature.
Document is, let's move on.
Okay, thank you. This is your response that you were talking about, and just in regards to critical mention, well, actually not just in regards, let me back up for a second. This letter, you said, despite consistent communication that I was implying that you were still in violation of the open records and you disagreed with my disingenuous implication.
Because it was. Yes, I made sure that I let you know that you are disingenuous and any implication that I violated the Open Records Act was as such. That was my word choice.
So the first request, the 5 things I asked for, you didn't give me any of those 5 things, and we've established that.
When you
Gave
say
me 4.
you,
Your office.
my office gave you responsive documents on January 18th.
No, it gave you 44
Some
pages of
responsive
crap.
Documents, but the 5 categories, and we agreed to that, the 5 categories, you said, no, you didn't give me the contracts, no, you didn't give me.
When
the
you say
payments.
you, my staff gave you responsive documents, okay? We have already said that certain things get elevated to me. You received the records. When
Jesus.
you did a second open records request for critical mention
Objection.
of those 5 things, as we have said, you
Non-responsive.
have addressed one. That one thing was
Jesus,
brought to my
shut
attention,
him
and I
up.
handled that.
Reel him in, Ashley.
So my
Shut him up.
assumption,
This
okay,
is so
to be clear
stupid.
for the record.
Because he
was
said
that
the same
first
thing 1,000
open records
times.
request, you
Just shut him
received
up,
everything. I
Ashley.
did not know what was in the 44.
Objection. Can you
did not
please
know.
have him
You brought
answer
it
my
up the second
question?
time. You did not
This is
make
like some
mention,
stupid
right,
speech he's
of
giving.
anything outside of those.
He's
4
given 12
those
times
5
already.
things. You only made mention of one.
Jesus.
So I dealt with that one.
Come on, Ashley. Reel
So
him
let's go
in.
down, look at, if you can make it a little bit bigger, where, he's referencing the actual numbers. So the open, yes, there we go. If you look at number 4, those 2 request number, the ones that end in 101924 and 011824. Those are the 2 critical mention open records. You cite both of those, correct?
We
All I'm asking is if you're citing those.
10924 or 44. Yes, I'm citing 2.
Okay.
2 open records requests.
And we can agree, those are the 2, we've already gone through the numbers for the record, those are the 2 open records in regards to critical mention, correct?
Yes.
Okay, and you said in regards to those records, you cannot produce the records we seek, correct?
I also said, as it relates to your request, those 5 things to view electronic communication, let me see, as written on January 24th, is not reasonably calculated to locate the records you seek. Can I explain why?
Just,
Okay, go ahead.
Ms. Ron, I'm gonna ask you about the second question, but I was gonna ask you about the first one first, let's try and finish that. And if we can stay on track, I will let you answer whatever you want.
Perfect.
The first line says, as such, we cannot produce the records because you do not maintain responsive records. Only talking about that line, okay?
Yes.
That's what that line says, right?
Yes, that's what that line says.
You wrote that line,
I wrote that line.
okay? So when you wrote this, you were telling me that you did not maintain responsive payment records.
That's not what I'm saying. No,
You did not maintain responsive contracts.
that's not what I'm saying. No,
You did not maintain responsive analytics.
that's not what I'm saying. No,
What the hell are you
You did
saying then?
not maintain responsive emails.
that's not what I'm saying. No.
Now let's go to the next one.
May I tell you what I am saying?
I assume you're saying you do not maintain responsive records.
Well,
That's
instead of
just-
assuming, why don't we let the witness do what he wants to do
Yeah.
and tell us why?
Great.
So we said that you gave me my first critical mention open records request, right?
I'm sorry.
You gave me my first critical mention open records request that I responded to on January 18th. On
No.
this,
You didn't
that you did
respond
on
to it.
January 18th, the first open records request.
You
the
didn't
5
do
things.
that. Your staff did it.
The first one was January 9th, the second one was January 8th.
The 5 things, critical mention.
Yes.
You accepted, you received those documents, that file was closed out. The second one, we're on the same page? You said, hey, I need an analytics graph. Based on this, number 4, I am telling you, I gave you all responsive documents. In the second one, you did not bring anything else up. The only thing that you brought up was analytic drafts, to which I responded in the second sentence, I don't even know what you're talking about. So again, when you gave me the first request, I responded. When you said the second request, you brought one issue. So the first sentence is related to the first one. I gave you
I feel like I've heard this
responsive
same conversation
I
14
assumed
times.
that you had everything that you needed. When you gave me the second one of those 5 things, you only brought forth one thing. That one thing is addressed in the second sentence, which says, I don't know what you're talking about. So that is how I handled number 4.
We've agreed. This request asks for 5 things, right?
For the record, you're referring to item number 4 on that
Yes. for the
document on the
record,
screen.
I'm referring to request that ends in 010924, the first critical mention request. That request, I asked for 5 things, correct?
Yes.
When you wrote this letter, I still had not received those 5 things. I received part of them, but not all of them.
I did not know that when I wrote that letter.
Okay.
What I did know when I wrote that letter was based on your second request for the record, last three digits 824. You made mention of the first one, which only talked about analytics graphs. So I assume the first one was complete. You had everything that you needed. The first one being last three digits 924, done. The second one, 824, I assume that was the only thing at issue. I addressed that 824 in the second sentence.
So you assumed that this was completed, but you did not know that.
Let me tell you why I assumed it. The answer is yes. The reason why I assumed it is because when you brought forth 824, you referenced 924, and as you stated, there were 5 things you were looking for in 924.
We
In
heard all this.
824,
Jesus.
You only sought one thing. I would assume, I hope I'm not giving you more credit than you deserve, that if you was unhappy with 924, just like you said as it relates to 824, I'm missing analytics, you would have brought forth those things in 824. You didn't. I assumed 924 was done.
Is it possible that I believed that you had complied with 010924 and given me any existence payments, contracts, and that I believed that they clearly didn't exist because you didn't give them to me?
When it comes to
Your Honor,
you,
objection, Your Honor's, false definition.
I asked if it's possible.
It's pretty argumentative, but I'm gonna let him answer. Go ahead.
thank you, Your Honor. When it comes to you and what I think you believe, it can be anything, Ashley Merchant.
So what a dick.
Okay, listen,
Okay.
everybody, we need to.
She's
dial
getting
all
mad
this
now.
out. The questions are,
Bad.
I feel like instead of being educated, I'm listening to an argument, and I'm tired of listening to an argument. I would like to be educated about the processes that Mr. Bond follows to perform his duties, and about what you believe, Ms. Merchant, to be the shortcomings of whatever those processes are, but I'm not getting that. I would also remind everybody that I can read quite well, and that most of what we're arguing about is reflected in written documents that are part of the record that I can review. Now, to the extent that the parties wish to understand what was meant by those words, those are fair questions. But half of our time has been spent getting people to agree that the document says this, or that the document says that. And I feel like if we would try to take off our, let's just, everybody take a deep breath, and please try not to continue to argue with one another. And that applies to both Ms. Merchant and Mr. Bond in terms of trying to answer the questions so that the court can understand what processes are followed and whether or not they were followed and should have been in this case. That's what I'm trying to figure out.
Ms.
Go ahead.
Thomas, when did you first learn that I had not received things in my first request?
The first critical mention request
Yes.
on your January 24th letter. That's when I realized, no, let me be very clear. On the first request, on the January 19th email, when you had made reference to the first one, you said that I am receipt of your records. These things are outstanding. That is when it was elevated to me, and that's when I became aware that you was missing analytic graphs.
Jesus, stop saying this
critical.
stupid analytical graphs
When did
thing.
you
I'm so
first
tired
learn
of this.
that I had not received the contracts that I requested in my first open records?
This lawsuit,
When did you first learn that I had not received the payments?
this lawsuit,
When did you first learn that I had not received the emails?
you did receive emails.
All of the emails? When did you first learn of that?
This lawsuit.
This lawsuit,
Thank you.
When this lawsuit was served?
no, during this preparation for this hearing.
So this lawsuit was served 7 months ago? Is that when you learned that I hadn't received any of the
Objection, Your Honor, was asked and answered.
No, it's not.
That question was asked and answered.
Overruled.
I'm gonna overrule the objection. I'm just trying to, I don't understand him to be making an argument. He's just trying to direct the witness's attention to a particular date. Go ahead.
When you say you learned about it when this lawsuit? Was it when the lawsuit was initially filed?
No, during the preparation for this particular hearing.
So just recently?
Recently, as it relates to critical mention in the lack of compliance as you allege with the first open records request. Because again, I resolved that matter. And again, the second one was brought up to me, and of those 5 things, you only made issue with 1, which I responded.
Stop talking about that stupid thing, jackass. Jesus.
And I'm gonna go to, merchant 0011, if you want to take a look at that. So this, when I got at the top.
We're
please
closing
log
at
in
4
and view
today,
letter
she said.
attached. That letter was from the office of the county attorney. Did you have anything to do with the drafting of that letter or this entry into the portal?
I don't know what letter you're referring to, I'm sorry.
It's at 0362 if you want to pull it. So, and just so the judge, so we can educate her for a minute, because I have one sorry. When this says that on the portal, I get this email, and then I have to go to the portal to see the letter, right?
I take you at your word.
Okay, well, we'll let you guys do this one. All right, so this letter. This letter that was received, and you can see it's got the open records request, and again, it's merchant 0362. This letter that comes from the office of the county attorney, it says to please log into the portal to see the letter attached. The request is being extended for research. That was sent on January, I think it's January 25th, January 25th. Did you have anything to do with this letter?
No.
And if you go to 0364, this is the next letter. This is February 7th. It says due to widespread outages, the request has been extended. Did you have anything to do with this letter?
So it's gonna be hard for me to explain. At this time, it was a cyber attack. The county attorney, because we use the same portal, gave us a template letter that we all use. So I can't make reference to this particular letter, but I do know that my office, had to send all requesters, including you, an update because of the cyber attack. And that letter appears to be a letter that I sent for all open records requesters at the time.
So this was sent February 7th. This was after you sent me the letter that said you didn't have your responsive documents.
I cannot speak to this particular letter. You said, look at this letter. I know that this is a template that so many people use. So I don't know if, I did not send you anything on February. I don't know. That letter was sent to everyone around that same time on February saying, hey, it's a cyber attack. Things will be delayed because we have limited access and things will need to change. As referenced earlier in our conversation about how the portal may change, and I alluded to cyber attack, this was a cyber attack. This is a general letter that wasn't just sent to you, it was sent to so many different other people because the cyber attack impacted how we handle open records and what we can do, how we can research and respond.
You can skip ahead to merchant 0167. This is a document out of your business record certificate from August 30th. Did you redact that redaction that you see in the middle of the page?
No, I did not.
Okay. You certified these records and signed a certificate and an affidavit, correct?
I did sign an affidavit that is correct, assuming that this record is in the 197 that I certified?
Mm-hmm. Yes.
What's the question?
Did you certify these records as complete and accurate?
The 197?
Yes.
The answer is yes.
Yes. And you did not do this redaction, and who did?
My counsel?
Your counsel did this?
As it relates to this particular, yes, I'm pretty sure.
Miss, legal counsel for the DA's office?
No, Ms. Allaby did not do that.
So who did it?
I don't know.
You don't know? So maybe it was Fannie Wills.
Let me clarify, because I'm not sure the line of question. I think that you received documents from me on my team that was redacted information. Typically, redactions are consistent. Do I do them? Yes, sometimes. Did I do them here? I don't think so, but I don't.
Who else could have? Give names.
Before preparing for this hearing, did anyone reach out to you about the complaint we filed with the court, the open records lawsuit?
This one, my counsel?
And you've been the open records officer this entire time, correct?
Entire time since when?
Since January of 2024.
Yes, I have been.
I'm talking about the critical mention payment. If,
I'm getting a lot of
we
these.
asked for
here.
invoices and payments and things like that. So I want to look at one of them. If you could pull up merchant 0371. Does this appear to be a payment voucher for the for critical mention service to be paid in 2021?
14 border. I'm gonna say yes. It's not the vouchers that I typically look at, but this does look like a payment voucher.
You can look at the next 2 pages. See if that looks more familiar.
Oh, yeah, there we go.
That looks familiar.
Mm-hmm.
And so this
Just
is
for the record, that was a yes.
Yes, I'm
Thanks.
so sorry.
so this document, for the record, thank you, judges, merchant 0372. This would be a payment for critical mention, correct?
This will be a payment voucher for critical mention, telling the county to, or informing the county that this particular payment is good to go.
Okay. And can you pull up merchant 0290? Do you recognize this document?
I have been presented to this document. Yes.
You've been presented this document. Do you recognize it?
Yes, I'm sorry.
Did you sign this document?
Yes, that looks like my signature.
And this is the check from FANI Willis, DA of Fulton County.
It appears to be so, yes.
Okay. And you've never provided me this document, correct?
If it's not in my 44 pages, the answer is no.
And who maintains this checking account, this bank account? Who maintains the records?
Who maintained?
Is it a DA's office checking account?
FANI Willis, DA of Fulton County.
Who maintains this? You signed it. Who maintains this document, these documents, this record?
I do.
And so you're the one that maintains checking account statements and this payment receipt, canceled checks.
The count, I'm not sure I'm understanding the question. When you
It's your
say,
checkbook.
you said what? This is
Your check, like who retains it? Who has the checkbook?
the office.
And as the records custodian, you have access to this checkbook.
Yes, I can, yes, that's correct.
What steps did you take to obtain a copy of this canceled check or bank statements to provide me to show proof of payment to critical mention?
Your first open records request, I gotta go back to it. I gave it to you as it relates to the response, and it was not elevated to me. Based on this particular lawsuit and preparation for this hearing, the steps that I took was to pull into our AMS system. Our AMS system looks like a PBX, right? Similar to what you.
Hang on, sorry.
It's a
You've
PPA.
just thrown out a bunch of abbreviations. I have no idea what either of them mean. So if you could educate me, I would
Understand.
appreciate it.
This is the education process. Forgive me. So, standard protocol. If you're looking for payment of vouchers, I would not go to a particular check, right? I will go to in my AMS system.
What's the
My
AMS?
financial records, our purchasing department, to say critical mention has a vendor code. Let's say for the purposes of this conversation, vendor code 123. I will go into AMS, I will look and say vendor code 123, how much payment has been calculated. So it would look as if it's the original PDX. Before to come,
PBX is,
payment voucher, I'm so sorry.
thank you.
So vendor code critical mention 123 was paid $10,000 and paid from this particular funding line X123. To me, based on your, not necessarily your open records request, your first one, but based in preparation for this litigation, that's what I would have done. Go to AMS to show you, hey, here is the proof of payment.
This check would not be in there though, correct?
No, typically no. No.
Because this did not go through the county
payment voucher vendor process, correct?
I cannot say that.
So my question again was, what steps did you take to obtain a copy of this check?
I did not take any steps to do this check. As I understand the subpoena at issue, right, preparation for litigation, you wanted payments and or proof of payment. My proof of payment would not have been this form. Instead, I'm trying to explain, my proof of payment was to go into a financial system to show critical mention, vendor code 12345 was paid $10,000 when in dispersed from the county on this particular date. That's typically my process.
Well, you didn't provide us that. We've never been provided whatever this process is you're talking about, that proof. So you've never provided us that though, but you're saying that that exists?
If it was not in my 44 pages, no, I did not respond. I thought on the first critical records, everything was resolved. I only moved forward from that first one with one issue. So as it relates to payments or anything, I have not moved forward with that because I thought it was resolved. So to answer your question, no. Now let me be very clear. As it relates to any checks for that matter, as I understand what you were seeking for, it was proof of payment. I would have did proof of payment a different kind of way.
Would you agree that this is proof of payment?
That is one type of proof of payment. The answer is yes.
A canceled check, you would agree, is proof of payment.
I would agree that's one type of proof of payment, yes.
And we talked earlier about records retention and that you have to follow the Georgia records retention. One of those policies is for your office to maintain for 5 years all canceled checks.
If that's what I'll stipulate to, if that's what the law is, yes.
And you comply with that law?
Yes.
So you would have had a copy of this canceled check?
I would also have yes, the answer to your question is yes, along with other various different forms of payment. The answer is yes.
Okay, and none of those were provided to us in response to our open records request?
If it was not included on 44, the answer is no, it was not provided.
Okay.
As I thought it was, as I assumed they were.
I only have one other question about critical mention, and then we can move on. Do you have a critical mention account login, or have you ever had one?
No.
So you would not have access to the online portal for reports and things like that for critical mention?
No, no one would. Now we don't have critical mention right now.
Okay,
So-
you've never had that?
No, I've never.
So if there was an open records request asking for information that someone obtained in that portal, that's not something you would ever maintain?
So I cannot say that. Critical mention is something that, just like LexisNexis or something like that, I don't use my username and password often, but if there's a record, I have several different databases as the business record custodian. If I have access to it, I can pull it.
So
So
you didn't have access to it, right?
I can get access. I think you and I discussed as it relates to the employment manual, right? And then you made reference, and you did
I'm so tired.
did very well, saying, hey,
Like 2 hours left,
investigators
like
and attorneys, they have
3 days.
phones and text messages. You brought that up. Then I said, hey, yeah, if they have it, I can have access to it, right? So the answer to your question is yes. If there's a system as the business records custodian and pursuant to the employee manual that you introduced to this court, yes, I can have access to it.
So if someone had the critical mention software or app on their computer or their phone, and they were running reports, you would be able to access that information and provide that in response to an open records request?
Not to your open records request, because on January 1st, 2024, or whenever you requested this analytics, one, I did not know what you were talking about, right? And then two, the critical mention did not exist. So no one on my staff right now can go into critical mention and provide any data, because critical mention does not, we do not have critical mention. So no, I could not provide you at the time the open records received responsive documents that you see, nor could anybody else in my office. What I could do is look at, like you gave me for subpoena number 2, which is more specific to your first 2 open records requests. I can use those particular search terms, and then I can give it to the Fulton County IT department, who has the ability to reach and try to find out information, which I did, right? And then which I provided to you. I think you referenced it as the 197. So that's what I could do, but I cannot go into critical mention. Neither myself, let me be very clear, or any other employee go into critical mention to pull anything.
Right, the people who actually had access to that at the time, those are the people that would have to pull that.
So I think that you and I can agree that open records do the records exist at the time that open records received. We made a lot of mention here that the first critical mention open records request came in January 8th, 2024. I think you and I can agree that on January 8th, 2024, we did not have critical mention. Based on the renewals that you showed me, we did not have an existing contract. So my position is neither myself or anyone with a login. The login is irrelevant. You could not get it because at the time your open records were received in January 2024, both of them, we did not have critical mention.
The law that we agreed earlier that you have to follow says that all records created or received in the performance of duty and paid for by public funds are deemed to be public property and shall constitute a record of public acts. Would you agree that reports paid for by public funds would be a record of public acts and public property?
I cannot answer that based on the framing of your question. I'm afraid it's misleading. Can I respond? My response is critical mention is something that is a database. Maybe we can educate on critical mention. Critical mention is a system that you can, an app, as you say, and that you can go in to get stuff, right? We use it for investigative purposes, if there is for various different reasons. Because HR is under me, I use it for morale. If one of my employees do something great and someone reports to that, I want to be able to let my team know, hey, this is what we're doing at the DA's office. That's how it is being used. Now, what I need you to understand is once that system is gone, that contract is gone, I cannot maintain, preserve, the system is gone. So I hear you as it relates to your assertion as it relates to the retention act, but I need you to understand that this app is somewhat, it's not a file that I will have in my office that I will have to maintain with the retention act. Am I clear on that?
Yes, you'd have to actually actively want to maintain it to maintain it. You have to print it and actively do something to try and maintain it, right?
If you have to want to.
You have to, it's an app, and if you want the reports to be retained, you have to download them, or you have to print them. You have to somehow do some act to make them be retained, correct?
I mean, I can go with that particular argument.
Okay.
But you have to also understand, just like any private company, and I think that you've seen in one of those emails, the 197 emails, that they're always saying, hey, look what critical mention can do. Hey, look what, so it's one of those things that I don't think that I'll just show my age a little bit. As it relates to, I'm not going to an app, Instagram, to print to retain. It's not one of those systems. I think that the court needs to be educated on what kind of system it is if you're going to implicate or try to infer that we was responsible for maintaining anything in that database under the Retention Act. I'm not gonna let you make that correlation.
But you were never the person who actually went in and did the reports and stuff. That was other folks. That wasn't your job.
Oh yeah, I have staff that can do things like that. I don't.
Okay, and the people that had the records would be Jeff DeSantis, FANI Willis, and Robin Bryant.
No, that's not true.
Who else had passwords to critical?
Jeff DeSantis had a password. I recall Robin, who's no longer with our office, had a password. I believe that password was sent to someone else, but I can assure you right now that District Attorney FANI Willis did not have a password. She can't work a printer. So that's not her. That's not her gift. She's blessed at a lot of things, but she will not have a password.
Blessed is a gift of mine.
And definitely Jeff DeSantis does.
Yeah. I would think that Jeff DeSantis would have a password, and undisputably not me, and undisputably not District Attorney FANI Willis.
I'm gonna move on to the.
He keeps bringing up Jeff DeSantis,
So we have another open
who they don't want to let him
request, and we've got
testify.
it up ready for
He's
you.
making
It's
it
at Merchant
essential for him to
0345.
testify.
would you agree that on January 9th, I requested any and all documents that employees, staff, or independent contractors, and I include agreements, are required to sign regarding speaking to the media and or confidentiality? Would you agree that I made that request?
January 9th, 2024, yes, you did make that request.
And that request was clear and concise, correct?
Not necessarily concise, and I can explain why, but based on this reading, I understand. I understand the open records request. My interpretation of this was that she was looking for statements that exclude people from talking to the media.
It clearly says confidentiality on this document, is that correct?
It does, yes.
So would you agree that that is clear and concise as far as confidentiality?
As it relates to speaking to the media and or confidentiality, just looking at this, I would agree that this is clear and concise, just looking at this.
And it was submitted through the Fulton County Open Records Portal?
That's correct.
And it was received, it shows it was received the same day, January 9th. That's the return with the tracking number, so that's proof that it was received, correct?
That is proof that it was received by our office and we acknowledged it via Open Records Act, yes.
And then on January 18th, it looks like I got a response that said to please allow for 10 business days for a response, correct?
That's pretty standard, yes.
So would you agree that within the 3 days of my filing this open records request, I did not get anything that said whether responsive records exist, correct?
Based on this, you got an acknowledgement of we received it and you got an R. So I don't know. Outside of this, I would have to agree with you that you did not receive whether or not responsive records exist in that 3 days time. So I would agree with you.
Okay. And I didn't get anything that says when they will be made available or whether they will be made available, correct?
If you can scroll down, I can tell you exactly what you did receive.
Oh, no, go back up to the request. Yeah, that's it.
And if you go down to,
I asked within 3 days, so you can definitely.
so for January 9th, this is what you received. Thank you for submitting your open records request. Here's your tracking number. Here's your description of records.
So, and going up on January 18th, that's when I received a response that said, please allow 10 business days, correct?
That's when you received a response through the portal. I do know that you and I, as well as my staff, exchange emails. I cannot tell you if you received a response anywhere between January 9th and January 18th. But just off this record, you received a response on January 18th. Please allow 10 business days for a response.
And while you mentioned that, your staff would email me for clarification if they thought anything was confusing, right?
My staff is instructed to, if you get an open records request and it's simple,
Look at him
go ahead and
sweating.
handle it, right?
Oh, he's
And I think
sweating. Jeez.
and I can agree on what is simple. My
Dang.
staff also knows we have routine checkups when anything that's
What was
elevated
that?
come to me and let's discuss. I do have competent people on my staff who sometimes will reach out to people to ask for clarification. I do have that.
And so the letter that was attached, if you can go down to the next page, it's merchant 0346. That's the letter that I received in response, correct?
Once your request has been reviewed, this is a pretty standard letter. I would say that you received that.
Okay. And so this was received
I remember ever
9
seeing
days
Jack
after I made the
sweat
open
that
records request, correct?
If
hard.
this letter is consistent with the January 18th, the answer is yes.
That was
And
crazy.
this is from your office, right?
It is from and signed Open Records, although, as you can see in the headline, who it is, but you know it's from Open Records. You do know that, right?
I'm trying to differentiate between the county attorney's office, which we've received some letters, and your office. This is from your office, correct?
Yes, because it has my office's letterhead.
If I could ask for a point of clarification on that, there was another letter we saw earlier, it's the one that related to the cyber attack, it appeared to be on
County attorney letterhead.
Ms. Miller's letterhead. The signature line said Open Records Team.
Yes.
Is that distinct from your signature line of Open Records?
Yes, and let me explain. And this is what I was trying to get to. The county attorney decided, hey, everybody that's involved in the portal need to use this standard letter for cyber attack. So that particular letter, as it relates to cyber attack, we were supposed to go and say to all our requesters, he is a cyber attack.
Right, no, that's fair. But actually my question is broader than that. It's not about that particular letter. It's about, is Ms. Miller and her open records team the same as Mr. Bond and his open records?
The answer is no.
Thank you. Okay, go ahead.
And so after I received this letter, let's see, is this, can you scroll down a second? Is this, 4-6? Yes, okay.
Now I can't stop staring at his armpits.
I followed up with a letter, the letter that we talked about earlier, the January 24th letter. I sent that to your office.
The January 24th letter came. At that time, like you said, there was several different things that was elevated to me, because at this time, this wasn't elevated to me. It was interpreted to me at that time of that letter that you wanted any documents that prevented staff or independent contractors from speaking to the media.
Okay. Let's, if you can scroll. Maybe on the next page. And this is the same, that's the same follow-up letter though that I included. I included essentially all of my requests, correct?
Possibly.
The ones that were outstanding.
It's more than 12, so I don't know if you said all. Earlier you said it'd be surprised 12, you remember? This looks like more than 12, so I don't know if it's all. That's something that you can clear up for the record. You remember I said 40, you said 12, this looked like in between. So I can't tell you if it's all.
Number 5 on here, if you look at the top, is about confidentiality or non-disclosure agreements, correct?
Yes.
And here again, I'm asking for confidentiality agreements.
Yes,
Would you agree?
I would agree. I will also say, let's look at the context. Let's read it. It says, district attorney required to sign regarding speaking to the media. To your point, and or confidentiality. So yes, I said signing, speaking to the media, to which I responded. Let's be very clear. So you going, I have no responsive records to any of my staff speaking to the media. That's how I responded.
Can you pull up the employee manual page again? Page,
What?
the
What you
employee
say?
manual. 0602. The employee manual actually contains provision that, see if we can get it up here for you, but it actually has a provision about talking to the media, correct?
No employee is permitted to talk to the media. I believe, I'm referencing.
And that's in the employee manual, though, correct?
It should be, you could show me, but I'm almost certain, because no employee should be talking to the media.
So if you interpreted that request to mean you can't talk to the media, you didn't provide this in response, though, correct?
This wouldn't be responsive to you asked for, let's go back to your open records request, because the two like minds were different. We learned that in law school, right? Look at your open records
To
request.
law school, this guy?
You're looking for agreements signed by staff. This is an employee manual that says you are not to speak to the media. In my professional opinion, based on my years of experience, the employee manual will not be responsive to your request. So the answer to your question is no, I didn't provide it.
And so in that letter, you didn't provide the confidentiality agreements, you didn't provide any of those, correct?
No, you're right about that. And I did not provide confidentiality agreements. The way that was presented to me was the media. I knew I did not have responsive records after talking to counsel, right? Let's be very clear. In your subpoena.
No. I'm not asking anything about the subpoena. I don't want to confuse the issues.
Gotcha.
I'm only talking about the open records. We are still in January.
I got you. So as it relates to open records, I interpret this as you do not talk to the media, to which I responded, you're right. I do not have responsive documents as it relates to making my employees sign an agreement that says you cannot talk to the media.
You put,
And that happened in January. That is correct.
I thought this guy was a clerk. I didn't realize he was a lawyer.
put his letter back up.
Explains a lot, though.
sorry, Mike, yeah. So go back up to the open records request, the actual wording. So I asked for documents, agreements, contracts, memos, or any written documents and that anyone's been required to sign regarding confidentiality.
So
It says media and confidentiality, so hold on.
I agree with you.
So in response to this, you did not provide any confidentiality agreements, correct?
The answer is agree to sign, so you know our employees don't have to sign employee manual. So we know that. So we know that that's not responsive. As it relates to the media, I'm agreeing with you, right? You asked for, I interpret this in my staff, you wanted media agreements. I responded and said, I do not have responsive
Media
documents,
agreement,
right?
ridiculous.
After this
interpretation.
particular litigation in preparation for this hearing, at that moment, it was confidentiality agreements, right? And at that moment, I believe as we sit here before, they have been
Basically, your
provided.
office is incompetent. So that's why they give
So-
nothing right.
They provided me
It's
2
like
days.
it's not malice. We're just
I cannot tell you when
stupid.
it was provided to you.
We didn't
but I do
answer
know
any of
that
your
you have
5
them,
things. I
because once
assumed
I've been informed,
that you had
hey,
taken
this,
care of it.
if I can,
I misinterpreted this request.
this particular has been a moving target. The first one, not perfect. I interpreted it as media. Once I said it's media, it's non-responsive. Later on, it was interpreted as, forgive me, Jeff DeSantis made comments to the media saying that these agreements were destroyed. To which I said, I don't have any responsive records. And then at that moment, it then turned to, is that you? And then it turned to this most recent, I think, subpoena was just pure confidentiality agreements. So yes, I agree. You narrowed it down to confidentiality agreements and you got confidentiality agreements. My interpretation is on the onset was media. Based on context that you provided, hey, the DA's office had some stuff, they destroyed some stuff, which I did not have that. And now confidentiality agreements I have.
Because it
I
was
have
destroyed.
you have it. There's no,
In January, in response to my
I did
open
not give you
records
any
request,
confidentiality
you
agreements.
did not give me any confidentiality agreements. In your letter in January, when we said, we're going to have to file a lawsuit to get these if you don't give them to us, you responded, you do not maintain responsive records and cannot produce the records we seek, correct?
That is exactly because I thought that the scope of that was the media. You're absolutely right.
And you actually provided a custodian affidavit with a confidentiality agreement signed by Nathan Wade in his divorce proceeding, correct?
You have to show me.
Nathan Wade's, of his business records. If you don't remember that, I'll get it for you.
This judge keeps a tough schedule because I gotta tell
As
you,
the
45-minute
business
lunch
record
break.
custodian of
No break
1,000
so
per
far.
year,
2 hours into the
I don't
afternoon
remember that
session.
particular one, but
It's merchant 0610.
yes,
That's a business record certificate that you signed in November. Oh, it's on the screen for you now. November of 2023, correct?
yes,
And attached to it is a confidentiality agreement. Is that correct?
yes, a confidentiality agreement, not agreement to speak to the media. As I told you, wish I was perfect, I am not. When I got your open records request, I thought it was exclusively, you cannot talk to the media based on context that you provided.
Context I provided? Can you put my original open records request back up?
Not via the open records act. Yeah.
I'm sorry.
Context you provided, you're going to the open records act. I am not scoped to the open records act. I'm saying context that you provided because you did provide.
Right,
But I'm
well,
not-
we're gonna put it up. And you can show me where.
But I'm telling you, it's not in the open records act. In one of
So
your
there's no context in this. Is that what you're saying?
only context is required to sign regarding speaking to the media.
And there's nothing in my letter where I said, if you don't give me these, we're gonna have to file a suit. There's nothing, it provided anything different than this, correct?
That's not true. Not in that letter on January 24th.
In regards to the confidentiality.
I do not believe that, but there's been emails, right? No.
I'm sorry?
On January 24th, you did not make any mention, you did not provide additional context as it relates to the speaking to the media on January 24th.
So when we had to file the lawsuit, the open records case here, you had not provided any confidentiality agreements. in response to this original open records
The
request,
answer is
correct?
no, as I thought that your request was limited to the media, so no, I did not have that.
Would you agree that the 22 documents that were provided recently, within the past week, would be responsive clearly to this request?
I agree, it is, for, as it relates to confidentiality. If it was presented to me as, hey, this is, we're looking for media and or confidentiality, I would have gave you those, but again, I interpreted let me take responsibility, I interpreted it as a NDA, a non-disclosure. I discussed that because I interpreted it as not to speak to the media.
And in regards to this confidentiality request, did you perform any searches in response to this open records request?
This is an example of, I will go to my investigative team. Do you have any, do these exist?
So in
And-
response to this, you went to your investigator team and asked if any of them existed?
Not in response to this, let's be very clear.
What did you do in response to this?
I interpret this as the media. I know that as a business record custodian, as a deputy of operations, I know that we do not have any requests related to employees, any signed forms saying that you cannot speak to the media. I know that to be certain. So I did not do anything as it relates to this open records request based on my interpretation. And my interpretation is because required signing regarding speaking to the media. So let me be very clear. For that open records request, I did not do anything because I read it as required signing regarding speaking to the media.
But you personally got this. This was elevated to you for some reason.
This was elevated to me, and when it was elevated to me, it was presented to Mrs. Merchant want media statements. Do they exist? No, they do not exist. To which I responded to your open records request, they do not exist.
Were all of my records requests after January 18th, were all of those elevated to you?
No, I don't. You have, again, we disagree on the number. We know there's a lot. If you have asked from my office back from September, a lot of standard things, all of which we responded to in a timely manner. I hope you can agree to that. So I don't see all of your requests.
Maybe it's an
Did
elbow
you sign a
patch,
confidentiality agreement?
but like in the wrong place.
No.
It's an
You never
armpit
signed-
patch.
You never signed one?
I don't think so.
You don't remember?
I don't remember. I don't think so. I do not think so.
Do you believe that only 22 employees of the district attorney's office have been required to sign a confidentiality agreement?
I don't have no belief. I don't have a position on that. I know my staff. I could speak for my staff. No. And what I think I gave you were,
I'm sorry? You think you gave me?
no, I can speak for me. I don't believe I signed one. I know that my staff, my direct reports, they have not signed one.
Your direct reports have not?
As it relates to my direct team, I did not administer, I did not facilitate the signing of those particular documents. So I cannot speak to that.
So at this point, the 22 that we've received, I heard testimony of 150 lawyers, 300 or something staff. Is it your testimony that in response, and we now don't have any semantics confusion, right? Like it's confidentiality agreement. Is it your testimony that only 22 confidentiality agreements exist from Fonnie Willis as the district attorney's term?
Based on my research and based on me asking around about confidentiality agreements, I provided that.
All right, let's talk about your research then.
Okay.
What did you do to respond to this request?
Security team, do we sign confidentiality agreements? This is executive assistant, do you have confidentiality agreements? Chief of staff, do we have confidentiality agreements? Oh, we do? Who? Why? Okay, get these, let me give these to the council. So that is a standard, when you get a request, hey, I'm looking for confidentiality agreements. I think that you can respect the fact that, hey, do we have them? Do we have them? Let me show due diligence. Do you have them? Do we do them? Do we have them? So
you did not do that in January, you did that recently.
that's correct. Because in January, as I stated, I thought it was limited to the media. I know media doesn't exist, so I did not very clearly do it in January. I did not.
And in response, you asked the security team, the executive administration, and the chief of staff if they had any of these non-disclosed?
Hey, remind me, hey, these was maybe done 4 years ago. Is this something we did? Do we have them? Who have them? Are they made? So yes.
What I'm trying to understand is if you're saying, swearing under oath, that 22 are the only 22 that exist.
I cannot tell you that.
You're
I
the
can tell
records
you.
custodian, right, for this office?
So but I can tell you what I did. When I got this, when council presented to me and said, hey, media, let's go, instead of looking at it from a narrow scope for media, let's look at it from a confidentiality agreement. Dexter Bond, as the business record custodian, what did you do? And I'm answering the question as of what do I do? Now you are looking at my efforts at what I did, and you're trying to conclude that my efforts yielded to a totality result. And I cannot confirm that. I can tell you what I did in good faith.
Did you send out an email to all staff saying, who has signed a confidentiality agreement? Please respond.
Oh, I didn't do that. No.
Did you send it out to all supervisors?
No.
Did you send it out to all attorneys?
No.
Did you send it out to anybody?
I'm not sure if I sent the email. I don't know. I made some calls and I had my team make a call, so I don't know. But I know only a handful of people can do RDA. I can tell you that right now, so I know that.
You can now, right?
You said what?
You can.
Oh, I can.
So if you wanted to, you could send that out.
If I wanted to, I wouldn't have. Yeah, if I wanted to.
So,
But also, if I wanted to, yes, let me tell you why I wouldn't though. I think you can respect that I get probably 500 to 1,000, maybe 1,500 emails a day. There's no way that I would send an RDA email and I would have to transport, hey, put this in this portal, so I would not have done that.
So how did you get the 22 that you gave us?
I think I answered that question. I told you I called the chief. I answered that question.
as how you got it, like literally how you got it.
I believe they were scanned to me.
Who's
It was
scanning
compiled
you?
and scanned to me. Can't tell you. I signed this.
I'm sorry?
I assigned it to someone.
Oh, who did you assign it to?
Probably my team. Hey, I need to do this. Can you take the steps? In a staff meeting, I cannot tell you who specifically did it. And I made some calls. That's why I know I had an email. Do we have this? Do they exist? Is this familiar? And that's what I did.
So you asked some staff, and you don't know who that staff person is, to make some calls to see if these exist.
So when we're in a staff meeting on Tuesdays, right, I have several different people that sit around the room, right? And then I would say, hey, these are outstanding issues. This is my elevation time. Like, if there's an issue, let's elevate this. And hey, you need these things for open records. Hey, can you take the lead on this? Take the lead on this. Take the lead on this. Report back to me on Thursday as it relates to what we did, how we did. In the meantime, I'll make some calls to figure out where we are. So that's my routine practice on open records.
And that request was done roughly within the last 2 weeks.
Oh yeah, that fairly recently, because again, when I first got the request, I thought it was related to the media. As my astute counsel said, hey, let's look at confidentiality agreement and let's make it a little more broad. I followed those instructions and I did, and I told you what I did.
Is there any way that I could have been more specific without using the terms actual confidentiality and agreement?
If I could, to be honest with you, no. Now, because this was elevated to me, I wish that this was a request that I would have read myself and not allow it to be paraphrased to me, because I thought that this was required regarding speaking to the media. I blamed it, okay, speaking to the media, and then I went ahead and said, hey, listen, I don't have it.
I'm sorry, who paraphrased this to you? I thought this one was elevated to you.
When it gets elevated, it's a series of things that's getting elevated. Hey, these are things that I look. There are certain times that I'll look and I'll read. I don't know what you're talking about. Let me read this. There are other times where it's just like, I'm looking for X. I will briefly look at it. Oh, okay, let's go. So I just want to be the elevation process. Let's educate. On Tuesday, we sit around the room. We have open records conversations among many things. Once that happened, if there's an elevation process, it was, hey, here are 15 open records items that we have. Do we have this? Do we need this? Is this an exception? Do I need counsel? Do I need to research? Do I need to redact? That's how it happens. Some of which are, hey, do we have media non-disclosure agreements prevent staff from media? That's a paraphrase. Or, hey, this person is asking for such and citing the law and such and stuff. I don't. Those are ones where I'm like, hold on, wait. So I want to be very clear.
Yeah, I want to be very clear too, because I'm a little confused now. So if it gets elevated to you, that's when you talk about it in these meetings? But otherwise you don't?
If it's a standard invoice, I thought I answered that. If it's a standard invoice or something simple, it doesn't get elevated to me. It gets handled by my staff.
Okay, so only elevated ones get talked about in this meeting?
in this meeting, or hey, Dexter, I need you to look at this. I need you to weigh into this. Yes, it needs to be brought to my attention. But if you're looking for something, as you have a specific contract, if you're looking for something specific and it is clear, it cannot be interpreted any differently, then yes, well, my staff has full reign.
So you don't personally review the request when it's elevated. It can be paraphrased.
There are times where if I have a 20 open records request that needs my attention, there are some that I can go through. I will take a quick gander. There are others that will require me to, hey, I need to make a call. I need to do something. I need some consulting. It's hard for me to tell you there's one way to handle 1,000 open records requests in a year.
And other than Erica, who you've mentioned, who else is on this team?
It depends. For example, if it's a big redaction project, I have to add someone. If it's a media project, I have to. So it varies based on staffing levels, workloads, and actually what I need to do.
Well, I don't want to belabor the point, but you were saying that some unknown staff, and you can't identify who it is that would have paraphrased this. Who else could have?
No. Okay. As it relates, I have one designated open records person, right? That what she has the authority to elevate. As it relates to handling matters, then I, because she's the only person, have the authority to say, based on the totality of circumstances, I need you to handle this redaction.
Okay.
I need you to look into this particular exemption. I need to. So let's be very clear. I got one person that open records is all they do. But as you know, sometimes redactions, exemptions, interpretations, those things can be out. No.
I want to try and get through the last couple areas. The next request I made, and this is at merchant 034 in case we need to look at it, was for, I specifically said, I am seeking personnel records. That's the first.
I would have to look at that open records
It'll come up in a
request.
minute.
Oh, okay.
It's
perfect.
merchant, for the record, merchant 0340. On January 8th, I said, I am seeking personnel records. And then I said, I'm requesting a list of attorneys with their names and date of hiring, hired by the district attorney since Ms. Willis became district attorney. And again, I stated, including the date of hire. This request was clear and concise, correct?
No.
It was not.
No. I'm seeking personnel records. I think you and I agree. What personnel records? That's a little overbroad and some. Then as it relates to the second part, I'm requesting a list of all attorneys with hiring dates hired by the Ms. Willis, the district attorney, FANI T. Willis, and to which I responded. So the first sentence, I'm seeking personnel records. I didn't know.
You didn't know what?
Personnel records, that part right there. I'm answering your question, was it clear and concise? The answer is no. Based on the first sentence, I'm seeking personnel records. The second sentence, you say that you need three things: a list of attorneys. Those attorneys need to have a hiring date, and that hiring date needs to be hired by FANI T. Willis. That's what you're seeking. To which I responded, I don't have responsive records.
So if you did not think that this was clear, did you reach out to me for clarification?
No, and I won't reach out to you.
And I think we agree it wasn't responded to within 3 days. I don't know.
I didn't agree to that. I'm telling you right now that I responded to that open records request, and I said I don't have responsive records.
I was asking if we agreed to that because I know Ms. Monroe was looking to see if she
Right,
agreed.
but in fairness, the witness
Yes,
didn't
I know, and I was trying to finish
That was a
that.
conversation we had before. Ms. Monroe, did you ever have it? I know we decided to go ahead and get started, and it seems like it's a good thing that we did. Do you have any insight as to whether there can be a stipulation about whether the responses that are at issue in this litigation, the requests that are at issue in this litigation were responded to within 3 days?
Okay, so the request regarding the forfeiture report, that request was submitted on January 18th, and a response was sent for an extension on that same day for 5 days. And then a letter,
Forfeiture is a
response
fund
was given,
that was used to pay
back
Nathan Wade. That's why she's
January
asking.
28th. So
It's money that
there
was
was a
forfeited
response
to the
within the
county.
3 days. It was just for an extension, but not for the provision of records.
Okay.
So,
Y'all can educate me to the extent you need to, but my understanding is that a request for an extension of time to locate documents can suffice sometimes, but at some point, there has to be production of documents within the requested time period, right? So if it's give me a document, within 3 days, you have to acknowledge the request and say, here you go, or we need more time to find it, which is okay, but then if you say we need 5 days to find it, you have to give it to them within that time you said
Right.
for it to be timely.
Right.
Have we followed that trail and determined if we can agree that records either were or were not provided within either the 3 days or the time period requested by the DA's
Extended
office to
time.
comply?
Okay, so as it pertains to the forfeiture reports, documents were not provided within 3 days.
Okay,
And then ultimately determined that there were no responsive records. And then in terms of the requests regarding rebranding, promotional materials, that was not in 3 days. And in terms of, and there were also no responsive records for that. And in terms of the list of hirees, which she's talking about right now, so yes, so that was actually responded to timely, but not with the records, but with a response saying no responsive records. So we had the response that was submitted on the 8th,
Basically, never.
and then on the 9th, a letter, which is the following day, a letter was sent saying that we need 7 to 10 business days to accommodate your request, something to that effect. I don't have a letter in front of me, don't quote me, please. And then on the 18th, which is within that 10-day period, there was a letter saying that no responsive records that was sent to the
Okay.
requester.
okay.
So out of the, sorry, I only gave, how many did I do? 1, 2, 3. And for the final one, the NDAs, the request regarding the NDA, that was not responded to timely, and nor were any responsive records provided within the portal under that request.
Okay, thank you.
So she basically got Jack crap.
Okay, so this was filed January 8th, this record, and the response was lodged January 9th that said you were in receipt of the records and to allow 7 to 10 days for research. Would you agree that the response within 3 days did not say whether or not responsive records exist, correct?
I would agree with that, but it did consistent, as I read, the Open Records Act lets you know what time frame.
Just
based
answer
on
the
sample
damn
level of
question.
workloads that I'm gonna be able to provide you, and it reads 7 to 10 business days, I need to do research.
And it doesn't say whether documents will be made available.
On the next day that you gave me this document, I could not make that determination. I needed to do research, so I outlined how long I needed to do research on 24 hours. Was it 24 hours? Yeah, about 25 hours after you received that. I acknowledged your receipt and I told you I need more time.
And then on January 18th, you responded that no responsive records exist, correct?
Let's see, January 9th, I told you 7 to 10 business days. Within 7 to 10 business days, I said, hey, we don't have any responsive records.
So that's correct?
That is correct.
And we're still referring to the personnel records request, is that correct?
Yes.
Okay.
Thank you. What efforts specifically did you do to actually locate these records?
Talk to my HR team, and I know for certain because HR reports to me that I do not have a list of attorneys, 1, hired by District Attorney FANI Willis, 2, with their hiring dates. Those are 3 variables that you wanted. I know for certain that I don't have that.
What searches were performed?
How do you know that?
I talked to my HR team, and then at that point, I know that I do not have a list of all attorneys hired by the District Attorney FANI T. Willis with the hiring date.
And
That took 7, 10
you also
business
then
days.
received, after this, so this was on January 18th.
That
I
3-minute
filed a letter on
conversation.
January 24th, again, asking for these documents. You received that letter, correct?
I do. And again, that particular letter had several different open records requests that was outstanding. Can't remember the number. I know it was more than 12. And I think I told you the same thing I told you on the 18th.
Do I look older than
that there
54?
are no responsive records because as I sit here today, I don't have any responsive records.
My question was, you received a letter from me January 24th where I asked for these again, correct? Did you receive a letter January 24th?
Yes.
Where I asked for these again?
I don't know if you asked for them again. I received a letter on January 24th. As we already said, that letter had several different open records requests.
That's what I
Yes,
thought.
this is probably included in the letter of more than 12 open records requests that I addressed from your January 24th letter.
Give us a moment. Hold up. I have a hard copy. It's 0080. For the record, it's 0080.
Could be correct.
0085.
He's quick in math. Unless my birthday was in October. November, December. Oh, yeah. That's of 69. But yeah, I was born in 70.
Take a look and tell me if that refreshes.
June 1970, if you must know.
January 24th letter. I'm assuming, so direct me, you're talking about section 3?
Section 3.
Yes.
So I again clarified, asking if this meant that she had not hired any attorneys or that you just were claiming that you didn't have a list.
Is that correct? Did you receive this?
I did receive this.
Okay. And before we move on, how many number requests are this?
Let's look. One.
You can look at the last one, your Roman numerals.
I'm glad they're done fighting.
Look at this
It's
number
really
one.
getting
You see
me.
how many is in here? So how do you want me to handle it?
So each are one request. So if you
It was
wanna look,
exhausting.
how many?
I'm sorry, Ms. Merchant, I can't hear you.
I'm sorry, here, I'll take it back and go and ask her.
Okay, go ahead.
Sorry, I forgot. All right, isn't it true that we go up to Roman numeral number 10 in this document? There are 10 requests in this document.
Ma'am, look at number 9. That is 2 requests in 9. So you cannot correlate Roman numerals to requests.
2 requests in number 9?
Look at 3, 4. I'm sorry. Don't know Roman numerals.
Objection, I'm sorry. I understand that counsel is trying to get to the contents of the letter. At this point, I don't see the relevance in having the witness count the number of requests in the letter. So if we could just get to it.
Just part of the argument has been that it's burdensome, that I've requested 40 we started with. There's 10. One of them I had to duplicate because it was closed without being responsive. There's 10.
The letter, I can read your letter.
Okay.
I know how to count and
Thank
read,
you.
right? And so there's no point in arguing about it.
You responded to that letter and said nothing exists,
In
right?
this letter, you presented 10 Roman numerals that dealt with a lot of different requests that was outstanding, but you so kindly forget that we have had several different open records requests outside of this particular letter, dating from September. So this letter only deals with open records that was outstanding. Each Roman numeral deals with various different requests. Let's be clear.
My question was, if you sent a letter in response to this.
You asked me that 3 times. The answer is yes. You received it on January 26th.
And it said that you do not retain records and cannot produce.
And I told you that 3 times because as I sit here, I do not have records. I do not have a list of hires from attorneys with the date of hire that was hired by District Attorney Willis. I told you that on the 26th in response to the open records request. I told you that now. And I told you that previously.
One point of clarification, because you've said the same thing several times, and you're putting emphasis on a particular part that I'm
Hired by
curious about.
FANI Willis.
Call it the rule of judge's interest. But I understand, and I think I started this hearing with this discussion about sometimes we know things that don't exist in a document. But you keep saying I don't have a list of attorneys with their hire date who were hired by Attorney FANI Willis, the DA FANI Willis. Weren't all the attorneys in the DA's office hired by FANI Willis?
Oh, no. We have some DAs that was hired by District Attorney Paul Howard.
Well, I'm certain they have worked for the DA's office for a long, long time. But didn't she decide to hire them when she became the DA? And I'm not challenging you. I'm just asking to make sure I understand if there is or is not a distinction.
I see that. Yeah, I can see that. But
Okay.
Okay, fair enough. I mean, but at least I understand better why you were drawing that distinction.
Mhm.
Okay.
Well, I was drawing that distinction because that's what she asked for.
Okay.
And
No,
I got you.
I wasn't challenging what it said. You were placing emphasis on it in a way that to me seemed to inform how you understood the request. And now I have a better understanding of how you understood the request.
Thank you.
Okay.
Thank you, Your Honor. I will say this, based on this particular request, what I have done is to reach out to the chief human resources of the county to see if I have a list of, hey, here are the list of attorneys hired by District Attorney Willis with their hiring date. And I can tell you right now, as I sit here, I don't have that.
When did you reach out and make that request?
During to the county HR in the course of this litigation.
Okay, so not when I filed the open records request.
I didn't have to at that time because I know I didn't exist. So the answer to your question is no, I didn't feel a need to reach out at that time.
But then in response to the litigation, you did feel the need to reach out and actually ask the question?
Well, once litigation is, I'm like, okay, what can we do to resolve this matter? Is there anything extra? I feel comfortable. Let's be very clear. Under the Open Records Act, I did what exactly is required to be the law. Now we're in litigation. Let's see if there's anything possible else that I can do. I did that extra, and guess what? The records still don't exist.
And I know we already verified that as an open records officer, you were charged with maintaining records under the State Records Management Act, correct? We already talked about that, right? Early on, that's part of your job.
The Office of the Fulton County District Attorneys seeks to maintain records and consistent with the State Retention Act. Yes.
And that act requires that your office maintain records documenting an employee's work history in a case file, including the date they were hired, and if there was no hire decision. And you have to keep those records for 50 years or 7 years following the date of separation of the employee.
That's what she's
And
getting
you're
at.
mandated to actually keep them in your own office. You can't delegate that responsibility to a central agency.
So you reading the retention law that I have not read, but I can tell you this. You started the sentence saying as it relates to personnel files. So you said case file date, right? In your open records request, you're looking for a list. I'm afraid you're misleading the court because you're convoluting a retention record that discusses personnel files, but you're seeking via the Open Records Act a list. Those are two different things. So let's not put the list into State Retention Act. They're two different things.
Did you
So,
have
hey.
personnel files?
Go ahead.
Did you have personnel files?
Did I or do I? Yes.
Both. Did you?
Yes.
And you did.
Yes.
And do those include the date that someone was hired?
Yes. The personnel file should have the date that they was hired.
Then why is this such a big deal?
Do I have a list? No. I don't have a list.
Did you have-
And if you think that it is reasonable for me to go look at find out who was hired by the DA, pull that HR file, scan that HR file to make a list, I don't think that the Open Records Act requires me to do so. So as I sit here, no, I don't have it, and I told you what I did.
Did you have a question? Nope. Okay, sorry. Thank you. Your office also.
And technically, he doesn't
needs
have to
list
compile
all the
something.
Employees of your office, is that correct?
Office morale.
That's technically
yes, we have
accurate.
bi-weekly
The judge even
newsletters,
made that
winter
point.
Reports, we have quite a few.
And it's got something called a directory? Of attorneys?
No. The judge specifically pointed out he doesn't have to compile a list if it doesn't
Yes, that's the
exist.
director.
That's not what the Open
And so
Records
someone
Act
has to get
requires.
this data somewhere with this list of attorneys, right?
I don't, unfortunately, what graphics does report to me, I don't know if they got a list of that, but I can tell you, I'm not, if I could, can I take a look at it again?
Sure.
All right.
While you're looking at that, I need to do a sort of check-in with my attorneys. I understood that the court reporter had made arrangements to be available till 5. Mr. Bowman had indicated he had an issue.
After 4. We're supposed to be wrapping up now.
Do we need to adjourn? Can we
Yeah.
carry on in your absence for an hour?
Let's
Can you
adjourn.
stay? Where are we on that?
Adjourn
Mr.
to
Bowman?
tomorrow.
Yeah, I can push it for a few more minutes, but I think
Whoa, that wasn't me. I didn't touch nothing. They just assumed 4 o'clock we're out. Let me see if the other one's still going. Hold on a second.
It's indicated that, you know. And
you guys publish these pretty regularly. The district attorney's
Five.
office publishes these regularly.
When you say
And
publish,
so-
yes, I print out.
That's all I
hand
know.
out, yes. I've learned that staff like to see their faces.
So we're just gonna continue on
And
at
if
5
you
and
welcome new
understood that
hires?
if you need to go for your prior issue, then you're free to leave and you don't need to ask my permission.
Damn it.
Thank you very much.
Damn it. I don't want to be here till
Thank you for the
5.
interruption. While we were doing that, the witness had an opportunity to look at whatever it was that you were showing him. I saw it, but I don't know that it was ever identified for the record. I
Oh, I'm
apologize.
sorry, Judge. I am showing him what is Bates stamped. It's, exhibit 8, it's merchant 0303, and it goes until 0336.
Thank you.
Let me know when, if that refreshes your memory.
I have reviewed this directory. I don't understand the relevance, so I'm pretty sure you'll educate me, so, yeah.
This directory is published by Congress, correct?
Yes.
And it contains.
Can you repeat that? I'm sorry, I couldn't hear you.
Sorry. This is a directory published by the district attorney's office, correct?
Yes.
And it contains a directory, which is a list of district attorneys, essentially.
This looks like my supervisor too. So district attorneys, supervisors, yes.
And you guys publish these pretty regularly. The district attorney's office publishes these regularly.
When you say publish, yes, I print out, I hand out, yes.
Every time I see
I've
his
learned that
armpits,
staff
I
like to see their
cringe.
faces places, so yes.
And in this, you welcome new hires?
I'm pretty sure that there's a version of, hey, we have some new hires.
And someone gives that data to whomever makes this brochure with new hires.
Someone's
correct?
got a list of new
Yes.
hires each year.
So you're able to give a list of new hires to the promotional people?
I did not say I gave a list, ma'am.
Someone's able to give that data.
Someone gave a
in some
list.
form, whatever form it's in, to this people.
We have new student orientation. They can be sitting there typing in the graphics saying, new hire Dexter Bond, Dexter Bond. So if you're telling me that a list exists, I'm telling you it does not. If you are trying to say that a list
That
of
sounds hokey.
attorneys hired by FANI T. Willis with the hiring date, which I don't see here exists, I'm letting you know right now that it doesn't exist. I don't know what correlation you have, but I see your directory. I see it. I see the supervisory, just not a list of all attorneys. I see it.
That
Your
sounds
office
really
pays attorneys
crap.
bargains, correct?
That sounds like crap.
Bardu's? Yes.
And they pay for continuing legal education?
So that's interesting. Do I pay for the training, go to the class? Typically, most cases, but you know, the $12 that you have to go to the bar to say that you have the 13 credits, now the bar, here's the $12.50 to make your account for the bar, I do not pay that.
It's
That was not an
$375
articulate
here
way of
in
explaining it,
New
but
York.
I have several different
$12
staff members who
in
want both
Georgia.
payments, and I only do one.
Let me see if I can
$375 every
drill
2
down on this
years.
For a moment. I don't think there's any dispute that the district attorney's office knows what attorneys work for it and probably knows somewhere when those attorneys were hired. Is that fair,
That's it.
Ms. Merchant?
I would assume so.
Okay. As I understand the disagreement here is that the DA's office understood you to be asking for a list. I think I've seen something indicating their position and some case law that says they're not required to create a record in order to respond. And so I understand that you're trying to inquire about where other lists might exist, but I do want to be clear that you're not suggesting that the defendants should have produced the personnel records of every employee that worked for every attorney that worked for the DA in response. You were asking for a list, correct?
Yes, well, and so understanding open records and normally, so purchasing, finance, all of those divisions, when I ask for an open records, if there's some confusion about this, they talk to me.
I understand all that. The only thing I'm trying to drill down on here is that you continue to ask questions about things that clearly indicate the DA knows who works for the DA.
Right.
I don't think that's really an issue. I understand you might be trying to get list adjacent, but I want to be clear that you're not saying they should have given you the personnel files. What you're trying to get to is you think there are things that might be a list that they could have produced. Is that correct?
Definitely. When I
Okay.
worked at the public defender, there's a list for bar dues. There's a list for CLE.
Thank you.
That's what I'm asking for. Yes. Saying these lists
different places that they would have.
have existed. They have to exist to pay parties and things like that. So that's
A fair point. That's an intelligent, thought out
alright,
thing. Like,
so
why would they have a list?
The
When you have
next
to have a list, you
area
have to take care of their bar
was what I would
dues.
consider rebranding and promotional materials. On January 17th, 2024, I requested, and this is at Merchant 0025, for the record. In that request, I requested any communications or correspondence between purchasing and the DA's office. And some of this was resolved and did not result in the lawsuit, but number two, the promotional materials.
Get out
I
of here.
requested
Where's
any
that?
payments, requests for payments,
Where?
hiring bids, paying vendors, promotional material, including promotional brochures, flyers, or mailers. Like this, promotional material.
Was
We
it
agree this is
California?
promotional material.
What about, no, because no, that is promotional.
Okay, for the record, you're holding up
I'm
something.
sorry,
Can you
I'm
say what it is,
so
please?
sorry, Judge.
That's okay.
I am holding up what was Merchant 0303, the front page of the Fulton County District Attorney's Office Winter Report 2024.
Help me to understand, and maybe I'm not trying to disagree with you, and I'm not trying to belabor the report, but what am I promoting in there? Why would that be promotional material? Promotional material to me is, our REACH program, helping the youth. Let's promote that. Our records restriction program flyers. Those are things that could be considered promotional materials. I don't know. I wouldn't consider that promotional material. I don't know what you're talking about.
Okay, so you considered REACH to be promotional material. Did you provide me that in response to this open records?
No, because you said in this particular open records request, any payment request process for hiring, bids, paying vendors, promotional material include. So no, I did not.
Rebranding. So when you walk in the district attorney's office and there's new advertisement type things, did you provide me any of that?
No, I don't know, because I do not even know what rebranding is.
So-
And for the record, remember, we just had a conversation about promotional material. As it relates to this open record request, you can agree, this is just like our first one, right? It's 5 different things. Of those 5 things, I responded. I think you told the court some of this has always been resolved because some of this did not come in. You said that's what you testified to the court. Hey, some of this stuff did not make it to litigation.
Right.
All right. So we also know once I gave you those responsive records, moved on. It was closed. So I gave you what I had as it relates to that. So if I did not give it to you when I responded to you, no, I did not give it to you.
Would you agree that this request was submitted on January 17th through the Fulton County Open Records portal?
It appears to be so, yes.
And it appears also that the request was received the same day?
It looks like I gave you a tracking number, and it was the 17th. That's impressive for my staff, so yes, kudos.
And it didn't say that whether or not responsive records exist or if they would be made available, anything like that, correct?
Well, on the same day, no, I certainly didn't think that you were gonna get a response on the same day. So it was acknowledgement of receipt, a description of your records, and a tracking number for you to find your record.
Then on January 25th, you put a response in the portal that says to review attached letter and that the request had been extended for research. Is that correct?
It does appear that is the letter that I gave you in January, dated January 26th, I believe. And it looks like I needed to do some research. So I agree with what's being presented to me.
What efforts specifically did you do to locate these records?
Well, I think that as it relates to these particular records, I gave you, number one, I guess this starts with 5. This is why things are difficult, right? You gave me 5 things. I responded to some. So as it relates to those particular records, I researched, retrieved records, and gave you records.
You believe you gave me records in response to this?
As it relates, you gave me 5 things in this open records request. Let's go through the first one, right? As it relates to number 1, I think that you told this honorable report that some of these matters have been resolved, right? I gave you those records for number 1. We can agree to that. Is that fair? As it relates to number 2.
No, it's not. I I received, number one, in regards to a subpoena in a criminal case from the county attorney's office. I did not receive that from you in regards to the open records request, so.
Okay, we're gonna have to disagree. Let's move forward.
So let's go through this then. This document, 0025, the only response you sent was on January 25th, where it says, please log into the portal to review the attached record. It's been extended, correct?
Let's look at that letter. Yes.
It's, if you can scroll up a little, it's higher up. There we go. Okay.
Okay.
And then, the letter that we're referencing is that same letter that you gave us earlier. It's at merchant 0087.
That deals with a whole lot of open
Yes.
records requests.
Yes.
So let's go to that letter.
And that's
Let's
it.
look at 011724.
It's 0087.
00. Okay.
And you wrote, in regards to this request specifically, that this office does not maintain responsive records and cannot produce the records I seek.
Show me.
It's number 5.
Number 5.
I can't believe that this judge hasn't given a break in 3 hours.
So that's 01924,
It's crazy.
right? Number 5, 01924.
Oh, so the
So you're
request, if
changing
you
numbers.
go,
I'm confused.
so the original request
What's the word?
is, oh, you'll go to the next page then. It's 011724.
Zero zero one seven. Okay, you can direct me.
It's number 8. Yes, number 8.
If that is 011724 related to promotional material rebranding, that's how I responded. Number 8. Yes.
So you never provided any records in regards to this response.
I cannot say that because that is not my contention. You asserted to this honorable court when you started looking at this open records request that this 5 things, some of them have been resolved and there is no longer in this litigation. So I cannot tell you 1, 2, 3, 4, 5 what I didn't do. I will take you at your word to say that some of those things, 1, 2, 3, 4, 5, was provided to you. So I'm not willing to say I gave you nothing when you have said, hey, I looked at it, some of the stuff has been resolved.
Do you have any knowledge as to how some of this stuff was resolved?
Objection, Your Honor. So it's my understanding that as it pertains to this request, that the only issue at hand was regarding the rebranding materials regarding rebranding and promotional materials. So if we
And the
could,
critical mention.
Okay, so tell me, Ms. Merchant, why in response to Ms. Monroe's objection, why if some of these documents have been provided to you at some point,
Why are
in
we
some
here?
manner, through some method, why is it relevant today that they were or were not produced in response to an open records request that you served or provided to the state?
It's not at all, but he said that part of this was responded to, that he responded to part of it, and that's not accurate. They did not, the open records people did not respond to any of that. It has been made moot outside of that in a separate litigation, so I didn't
So-
include it in the lawsuit, but he is very literal with these words, and so I was trying to, like, that one request is not an issue, it's trying to save time by taking that request out, but then the witness has now said, well, when we complied with it, and they have not actually ever complied with that. So that's not accurate.
Okay. Again, I think we're getting bogged down in semantics. The fact that the information and data or documents that were sought by plaintiffs at various points through their open records requests have now at some point been provided to them is not the same question as were they produced in response to this Open Records Act request, and if so, when? And so to the extent that's the conversation we're trying to have, that's allowable. And with that clarification, please go ahead.
Thank you, and I'm trying to be clear. So in regards to this request, what did you do to actually locate any records?
Received that particular open record request. I went through it. I cannot tell you if this particular request was elevated to me. I do know that I do not know what rebranding is. I do not know that I do not know what promotional material is. I do know that I responded to that. I cannot speak generally about this, specifically about this open records request, but I would have done to this request what I have done in all.
Did you ask for any clarification if you did not understand what the term promotional material or rebranding?
I don't have a duty to
I
ask
will
for
not, I've
clarification.
said this to the record and I'm gonna repeat this again. I'm not having a private conversation with you, Ms. Ashley Merchant. So no, I would not contact you. I am not going to email you. I am not going to talk to you to look at any clarification. I find you to be extremely disingenuous, so I won't talk to you. And clarifications
talk
don't
about
require
who's
me to reach out to you. What it does for the open records request is require you to put me in a reasonably calculated situation to give you what you have. But let's be clear. If you think that I'm gonna reach out to you and talk to you, I'm not.
The fourth request, critical mention, any payments, requests for payments, bids, or paying of critical mention. Did you do anything in regards to that request?
So
This
we
is-
talked about critical
No,
mention.
it's not.
That
Because
was-
I had to ask for.
No,
the
it's
third.
not.
And so in regards to the third request, where I asked for the same check that we now have gotten from critical mention, but not from you, did you do anything?
So I'm gonna repeat this for the third time. The critical mention came in on January 8th. On January 18th, I gave you 44 pages. On January 19th, you renewed the request. Again, the first request had 5 different things. On January 19th, you only elevated one thing. I assumed on January 18th, you got everything. Because when you don't have something, you elevated that one issue. I then worked to work on that one issue that was elevated. So to answer your question for the third time, no, I did not give you anything on January 18th. I assumed that the records was responsive and they were complete.
So
You
I
gave no
assume,
records in
and I don't
response
have
to this
conversation with
request.
you.
Not,
And the
According
first
to
time I
number
ever heard
8,
from
I
you
said
was
the
when you made
Office
this
of Fulton
first
County
request.
District Attorney in its normal course of business
Yes.
does not maintain responsive records. As such, we cannot produce the records you seek. Number 8.
I asked you what you did to locate the records to give me that answer.
Mhm.
Who did you ask for records, if anybody, to give me that answer?
Let's go back.
Who did you ask, if anybody?
I have to see the
Give
request.
me that
This
answer.
request was 5 different things. So if you, again, 1,000 requests, right? What we have discovered right here is all your requests came in
Oh.
from September and a lot came in January, right? So in this particular January, I have to go back to it to tell you what I did on these 5 open records requests. So if you can put those things back on the court, I can tell you.
Oh, I'm not asking about 5, I'm asking about number 8. It's open records, number 8. That's the only one I'm asking about.
Gotcha. So we can agree that number 8 corresponds to your open records request. Your open records request seeks 5 things. If you can put those 5 things on the screen, I can answer your question as to relate what I did for 1, 2, 3, 4, 5.
Okay.
I can make
Merchant
2 easy.
0025.
As it relates to branding and promotional, I don't even know what you're talking about. So I told you, let's move on.
Merchant 0025.
It's such typical clerk arrogance. I don't like you, so I'm not talking to you. It's your freaking job. Do your friggin' job. Don't pretend you don't understand. I don't understand, and I'm not. It's like, who the hell are
All right,
you?
here it is.
Number 1, outside counsel. That was a.
I'm not asking you about that, so we can move on. I haven't asked you about that.
Okay.
In regards to number 2, I know you said you don't know what promotional material means, but what, if anything, did you do in response to try to find responsive documents for this?
Can I tell you what I did specifically? That's a conversation with staff because my POV may be limited. What are promotional materials? I don't know. So I don't know what I did specifically. I don't know what. But what I did do is say that I do not have any process for hiring and bids for paying vendors for promotional material. I don't have that.
Number 3, rebranding. Any payments, requests for payments, process for hiring bids and paying vendors for rebranding material. Did you do anything in response to this request?
As a COO of the office, I know about bidding, and I know that there is no hiring or bids related to period. As to certain things. And then as it relates to rebranding specifically, I don't know what that is.
Did you do anything in regards to this request?
So I don't know what it is. I'm not going to bother.
I
asking
reviewed
you.
it, I accepted it, and consistent with the Open Records Act, I gave you a tracking number and I responded to it. So yes, me or my staff did something to this.
did you do any searches or request any records in regards to this?
As it relates, I'm gonna say yes. You don't want to talk about number one, but I'm pretty sure that I did a search because you have those responsive records. As it relates to number two, promotional material, I told you I do not have process of hiring bids. It doesn't require me to do research on that. As a COO of the office, I know the answer to that question. As it relates to rebranding, I think the court and I can all agree, right, that this particular matter, I don't know what that is. As it relates to critical mention, I have discussed several times what my position is as it relates to critical mention. And as it relates to TDI, I did respond. There is no responsive records to that. So did I do something? Yes, I responded in compliance with the Open Records Act. That's what I did.
So my question was, what did you actually do to locate the records? Did you perform any searches?
You say you
There were no
responded.
searches to perform outside of number one. So I'm pretty sure I did a search for number one. As it relates to number two, there's no search because there's no process for hiring bids.
That's
for
it.
promotion.
There you go.
So
For
tell
number
us
three-
what you did in regards to number one then, since you brought it up.
What I would do with any payments, because you requested a lot of payments, right, in previous open records. You requested a lot of contracts. That is something that I can pull as it relates to EMS and provide to you.
I feel like sending him like a dozen
regards
different
to number
open
one,
records
can you tell us
requests
what you
right
did?
now.
Again, Your Honor, this is
Imagine
outside
if,
of
like-
the scope
if, like,
of what's
half the
what
people watching
open
me
record
right now
requests
were
are
just
at
send open
contention
record
here. If
requests.
we could just focus on the open
branding.
record requests or the materials that are missing and that
Fannie
have
Willis
not been
stuff.
provided.
Judge, I think deserve an answer though, that nothing was done.
Hang on. I'm gonna save you the time and trouble of making that argument and say, I agree with you that what he provided in response to this request isn't relevant, but the process that he followed, the effort that he made to respond to it versus others, or in a similar way as he made, as a process he followed to respond to others, I think is relevant. And so I'm gonna let him answer the question. Your objection's overruled.
Repeat the question, please.
In regards to request number one, outside counsel, I requested any payment, request for payment, process for hiring bids, paying outside counsel, including the referenced retraining, which was discussed during the Board of County Commissioners meeting in November 2023. You'll remember you appeared in front of them. There was a big discussion about this. What did you do in response to that open records, number one?
I cannot recall specifically. I cannot recall.
Do you recall if you did anything in regards to this?
I can speak generally what I would have done. I cannot recall specifically as it relates to this request.
Listen, after listening to this guy, I think many of you might have open records requests that you want to make. So what I'm going to do is I'm going to pin to the chat a link in case any of you, perhaps many of you, have open records requests you'd like to make of Mr. Dexter Bond.
So how can you tell us that it's been fulfilled then if you don't know what you did?
Because as it relates to outside counsel, I cannot specifically tell you what I've done. Generally, for payments, I would have looked to see if there are any outside vendors which you have asked me for via open records request, and I have supplied to you responsive records to this. So I don't know how to answer your question, and I cannot specifically talk about tracking number 11724.
What did you do to search for information about the retraining that was required during the Board of County Commissioners meeting? And you remember attending the Board of County Commissioners meeting in November 2023?
I do.
And you remember there was a big discussion about the DA's budget for things, printing,
I'm about to post it. Please don't harass him. Please don't harass him.
promotional material, things like that.
That's not how it was reframed, but I do remember that I was present. And
This
I
is for
represented the
informational
office at that
purposes
BOC.
only.
And the purchasing department had some concerns because you had quite a few outstanding debts or
Sorry,
payments.
what department?
Purchasing.
Purchasing. thank you.
Sorry.
That's
Had concerns about all the spending for promotional material.
That's a mischaracterization of the purchasing department.
Okay, I don't want to get down into the weeds of because also there's an official record of what went down at the BOC meeting on whatever day, and if it ever becomes relevant, I can find it and listen to it and know what was said. So let's move.
Yes, okay. What is relevant is what did you do in regards to when I asked for the communication that was referenced at that meeting? Purchasing said they had gotten with you on retraining your office about purchasing. I asked for that communication. It was referenced during that meeting. What did you do to find that?
That particular training was done by me and the CFO. It was a conversation between me and her. So there is no documents related to that particular training. It was done via Zoom. So that's how, again, I cannot tell you specifically what I did with this open records request. If the conversation is about this particular training, I can tell you what it was. I can tell you that your statement of the purchase department is mischaracterized, and I can tell you that there are no records related because that happened via Zoom and we had a conversation about how to proceed forward.
So you did nothing in regards to looking for correspondence about that, setting up that Zoom or anything like that?
I know I would not set up the Zoom, so no.
Let's move on to the forfeiture reports. So on January 16th, this is at merchant 0019. January 16th, I requested reports and itemization for all property and funds obtained through forfeiture.
If you can, don't recall the characterization of that open records request. If you can allow me to see it, I will definitely bring you up to speed. Yes, familiar.
And this was submitted through the open records portal.
Yes, it appears it was submitted January 16th. Good job, staff. They responded. They gave you a tracking number on January 16th.
And the response or the request was clear and concise, correct?
Actually, no, it was not.
So you didn't understand what I was requesting here?
No, I didn't. I communicated that to you.
You communicated that. How'd you do that?
January 26th letter.
You communicated that you didn't understand what I was requesting?
If you can pull up the January 26th letter, I can reference what you're saying.
Sure. I'm the base.
Do you have a physical copy of that letter you can give the witness for reference to the mouth
Yeah.
that having to stop and pull it up each time is, thank you.
Thank you.
So before you go any further, is this the first time you responded to me in regards to this forfeiture request?
No.
Okay, well, you said that what I was asking for was not clear and concise.
That's correct. So, and I told you that, and you gave me this letter, and I'm about to tell you what I communicated. Is that fair?
So you're gonna tell me where you told me it was not clear and concise?
Yes. Do you want me to tell you?
That'd be wonderful.
Let's look at the letter January 26th. I'm gonna direct your eyes to footnote number 1. Footnote number 1 reads, we believe, emphasis on we believe, you are seeking the office's equitable sharing agreement and certificate. These records were filed in accordance with law, state and federal law. And I want you to, let's go back up to number 6, because you're talking about 011624. I say to you, responsive records are attached. So in this particular letter dated January 26th, I respond to your open records request number 6. I let you know that these records are attached. I give you a footnote, and that footnote lets you know we believe. And if I can, don't want to talk too much, but let me tell you why I believe what I believed. You want me to go there?
No, I mean, if there's something that's relevant to this, but I mean, this is the only response that you're saying you have, right?
For number 1, yes, as it relates to the office's equitable sharing agreement and what I believe that you're looking for, and I can tell you what I did to give you that.
Oh, okay, yes, that would be my next question. That's jumping ahead. Give me one minute to get there. So this response, this one that you sent, and I don't have the date. You've got my copy. It was sent, I believe, January 26th, correct?
Yes, January 26th.
Okay.
I agree.
Can you pull up merchant 0018? So after that, on January 28th, we received something that says apologize for the delay. So after we received this letter, there was an apology for the delay and said that it was still pending.
I'm looking at, what date, January 28th?
January 28th.
January 28th, it reads, this correspondence in response to our response, we apologize for they have additional time needed to fulfill your request. January 28th, yes, it does appear that, if I can, on January 29th, it says all responsive documents were emailed to you on January 26th, 2024.
So I'm trying to take it one step at a time.
Understood.
My question is, on January 28th, 2 days after your letter, there was an open records response that said They apologized that they needed more time and that it was still pending, correct?
That is correct.
So
It
then-
appears to be, yes.
All right. Then after that, on January 29th, I received another response that said responsive documents were emailed to me.
On January 29th, and then it says it was emailed to you on January 26th prior. If I may, that was on about where the cyber attack was. So in an effort to communicate to my staff, to all requesters, including you and 1,000 others, we wanted to make sure that everyone has a response that things have changed. So to me, you got a letter on January 18th. I responded to you via email on January 26th. My staff went around this time, hey, let me tell everybody that there is going to be a delay because I don't know what's going on with the cyber attack. On January 29th, it was all responsive documents were mailed to you on January 26th. So I want to clear up that.
Yes, that's what I was trying to get at. So at that point, all you had given me was the equitable sharing summary, and you were saying that's all you have. That's all the responsive documents, correct?
Based on your open records request, that was all all the documents. That's correct.
What efforts specifically did you do to locate the records I requested?
Oh, that was, I didn't know what you were talking about, but you said that this was filed with the county and local governing authority. So because it was filed with the county and local governing authority, I called the clerk. I said, hey, clerk, is there anything related to this particular account that I particularly filed?
So hold on, so you contacted the clerk in regards to this response?
Yeah, I contacted the clerk of
That's the clerk of court.
clerk of BOC, I'm so sorry.
That's okay.
The clerk of who?
Board of Commission. You said that I had filed with the Fulton County, a local governing authority. So because I'm taking you at your word, if this is something that I had filed with them, I called the clerk of the Board of Commission. I'm so sorry to say, hey, is there something that I filed with the clerk of the commission?
So when did you do that? When did you contact the clerk?
Probably any time between January 24th and January 26th when I responded to your letter, because I had to get the copy to provide to you on the January 26th letter.
And you spoke with the actual clerk?
I don't recall.
Was it by phone or was it by email?
Can't remember.
Did you use a county phone?
I can't remember.
Were you in your office when you made that call?
I can't remember.
Was it a woman or a man?
Your Honor, objection. The answer was you check with the clerk. That should be it. What is the relevance of the gender of the clerk? This is irrelevant.
It's argumentative.
Okay.
I understand what you're trying to do about what, maybe refresh his memory about who he spoke to, but you've made your point. Let's move on.
I'm trying to find out who it is so I can ask them if they spoke. That's the only way I can ask that. But I'll move on. So you talked with someone at the clerk and they said they don't have anything in regards to forfeitures?
That's not what they said. I said, hey, based on your request, right?
Mhm.
You said that you can we pull up your request so we can read it verbatim? Okay, sorry, glasses off. Can we go down? I'm sorry. It says reports and itemizations that were required by law to be submitted to the county as a local governing authority, showing what was done with all property and funds obtained through forfeiture, including but not limited to reports showing the funds went and who was paid out of funds. That's what you did. What did I do? I called the clerk of courts. I said, is there a report, clerk of board of commission? Is there something that I file that deals with property and or funds related to forfeiture? They gave me the equitable sharing agreement. I gave it to you. In footnote 1, I said, we believe you are seeking the office's equitable sharing agreement and certificate. These records were filed. Again, I say responsive records are attached.
Who gave you the equitable sharing agreement?
I can't remember. I know who I called. I don't know who responded. I don't know, but I recognize that this was something that was filed with the local governing authority. It dealt with property. It dealt with forfeiture. I sent it to you free of charge. I do know that.
And did they send it to you by email?
I can't remember.
He's already stated explicitly that he does not like her, and that he's going to stay as far away from her as possible and be as difficult as possible.
No, because at that time I gave you exactly what you was looking for. You looked for Reports and itemization filed with the local government authority. I called the county. I said, is there anything filed with this property and seizure? They said it's the equitable sharing agreement. Oh, here we are, responsive. Here you are, free of charge. Item number 6, address closed.
That's
So
fine.
no other searches.
You did no other searches?
No,
Okay.
no, ma'am.
So you didn't obtain the document that you filed, that you also had to file, talking about, the equitable sharing is the federal one. There's also a state one for state forfeiture funds. Did you file it? Did you search for anything in regards to that?
You're educating me. Say it one more time.
There's a federal forfeiture law and a state forfeiture law. You have to file reports for both.
Did you say that in the open records request?
Did I tell you that you had to file reports for both?
No, you're distinguishing state versus federal, right?
No. You said you gave me the equitable sharing. Equitable sharing is a federal Department of Justice document. There's also a PAC document for forfeiture. 2 different funds, 2 different tracking.
Receive.
Did you give me anything about the state tracking?
No,
You gave me the federal equitable funding.
because that's what you asked for. You said, give me the documents that was submitted to the county, Fulton County, as the local government authority.
They're
So
both submitted to the county. My question is, you gave me the ones, the federal forms. Did you do any searches for the state forms that you are required to do for the county?
no, I did not. What I did do was call the clerk. The clerk said, I have a forfeiture account based, your open record says local government authority showing what was done with property and funds to forfeiture. It makes no mention of the distinction that you're drawing today. What you're drawing today is completely different. What I did say is say, hey, I have a point of reference, local government authority. Let me call the local government authority. They say, I do have something through forfeiture. I get it. It's responsive. I say in my footnote, we believe you're seeking this.
Okay, my question is, did you do any searches looking for the state documents? Any searches?
No,
Okay, can you pull up merchant 0571?
but why would I? No, the answer is no. And I would not have done that because you said filed with the county. So why would I then say, hey, I filed with this county, but maybe she wants to look for the state? I do not. You and I don't think alike, clearly.
Let's back up first.
Mm-hmm.
The federal forfeiture statute requires you to do a document called equitable sharing.
And
It's
if,
news to me.
and if she said county or state, he'd be like, "Oh, I missed that part."
Objection, Your Honor. I'm sorry, assuming facts is not in the evidence and is also
It's in evidence.
Ms.
Very-
Marshall, let her give her objection.
yes, that is my objection.
I'm sorry, because of the crosstalk, I understood. Is your objection is facts not in evidence? Is that your objection?
It's not well, it assumes a fact that is not yet in evidence.
That's yes.
That he filed this every year.
So, I don't really think there's a dispute that the DA's office actually files this document every year because they do, but
But whether or not he filed it every year.
I was gonna agree with you, right? That whether he has any knowledge of the DA's office's compliance and requirement to do
So it's
so,
a
I have no
foundation.
idea. But
That's foundation.
what I am gonna back up
That's
to
not
is,
evidence.
I think you've asked, and he's answered multiple times, what effort he made to comply with that request. And I think his testimony is that he reached out to the clerk of the Board of Commissioners, and they shared with him information about this equitable sharing agreement. He believed that was responsive to your request, and so he identified it, produced it to you, and that was the end of what he believed was his response. That's what I understand to be the testimony at this point. And let's move on from there.
If you look at the merchant 0571, got your name on the front of the document.
What, educate me, this document is what? What is this?
All I asked is that your name on the document?
I see 2 names. Yes, Dexter Bond is on it. Dexter Q Bond is on there. Yes.
And it lists you as a deputy of the circuit attorney operations division, correct?
Yes, but the email associated is Natalie Zellner, last name spelled wrong, so. Okay.
Yes. Have you ever seen this document before?
Counsel has presented this to me,
The county attorney?
my counsel.
Okay.
Ms. Merchant, can you tell me why it matters if he's seen that document before?
Yes, because he said this is one of the documents I was asking for. And he's seen it, he filed it.
Hang on. You're asking him if he's seen it and if he filed it.
Yes. So
Okay.
first I'm trying to identify.
Now I understand why. That's all I asked was that's why you're asking, because you believe that document was responsive to your original Open Records Act request and he did not provide.
Yes.
Is that fair?
Yes.
Okay, go ahead, Mr. Bond.
So, in your astute research, it appears that you show 3 different forms, right? In those 3 different forms, each year, there was a different filer, right? So we do know the first year that you received, my name is not on it, okay? The second year,
Judge, I haven't asked him about any of this.
my name is not on it.
Hang on. Sorry, I apologize. She didn't start it with the word objection, but that's what she's doing is objecting to your answer. So I'm going to deal with her objection before you continue your response. Yes, ma'am.
It's non-responsive. I didn't ask about all those other ones. He didn't have his name on those. They're not relevant. If we're gonna go through those, we can, but I'm asking about the one that he signed as an example, that this would be responsive and it doesn't even have anybody else's name on it. So I wasn't gonna go through all those other ones.
Okay, so let me back up. Are we still talking about the document that's on the screen?
Yes.
Okay, you just said he signed it. I don't, Mr. Bond,
Sorry, I'm so sorry.
let's be clear about what representations we're making. His name.
See, he's a very difficult witness, purposefully being difficult. And frankly, this is what I was talking about from the very outset with her. There's a way for attorneys to deal with this type of witness that she is just not employing at all. You have to be succinct. You have to be very direct, and you have to be yes or no this, yes or no that. Build your blocks up. And she's not doing that. And that's part of the reason that this is so frustrating and aggravating. And that she's getting frustrated and aggravated. But frankly, it's a matter of her asking the questions better. Her specialty is in being a bulldog, in checking things out and not letting things go and going through with the paperwork. She's also very good at making legal arguments in general. Her questioning of witnesses, though, leaves something, in my opinion, to be desired, and we're feeling the effects of that for the last 2.5 hours because she's not being direct. Even when she's making objections, she's not saying objection. So the judge is being generous in basically listening to her and being kind to both sides. That's just her style. But what I'm saying is, she looks very frustrated right now. And frankly, I don't feel like she's actually winning this argument. I don't feel like she's winning because he's getting away with basically giving all his explanations as to how he was technically complying with the law while still being an a-hole. And he is being an a-hole. He's being a douchebag and a jerk. And he's trying to be as difficult as possible. But that doesn't mean that he's not technically complying with the law, which is what he has to do. He's allowed technically to be a douchebag. He doesn't have to follow up with her. And she's not doing enough, in my opinion, to sort of spell this out. What she has gotten from him is, there are other people here who might be necessary witnesses. And perhaps that's all she needs to get. But she's not being as effective as she could be if she was better at handling this witness. That was my whole point with that.
Name appears on this document that, at least to my eye, appears to be electronically generated. So ask him factually based questions about his involvement in that document and its creation.
See, that's what the judge is hitting on right now. Ask him basic, simple, fact-based questions. Set him up, and then you can basically follow up with that. But she's just sort of, she's like here and then there and then here and then there. Her legal arguments are way stronger than the way she handles these witnesses and sets them up.
And then we'll be good.
That's what I did, and he was referring to the other 3 documents.
And in fairness, I agree with you, and I've asked you multiple times, Mr. Bond, when she asks you a question, please answer the question she's asking, and then feel free to explain if you choose to do so.
It's not. The judge has been very. He spent 2.5 hours with this.
The document that we're looking at, is this something that you file electronically as part of your job?
The answer is no.
No. Do you have anything to do with this document?
Not this document, the answer is no.
Do you have anything to do with the filing of let's see what they call them, the Civil Forfeiture Procedure Act documents?
Now
We're
she's
not
doing
producing
that.
this document, the answer is no.
I'm sorry?
You said, do I have anything
to do with the filing of these? These are filed with the
The
state.
answer is no.
So you do not participate in these documents being produced.
No.
So someone else would have submitted it under your name.
I cannot tell you what someone else did. I can tell you, and forgive me, I am going to go on a slight tangent,
No.
but I never signed my name Dexter Q Bond. And two, my name isn't signed here. It is typewritten, and I would think that whoever is the signer would have that corresponding email address. That name, Dexter Q Bond, is something I don't go by, okay? As it relates to Natalie Zellner, that is misspelled, that last name is misspelled, and that email address, I would assume if it was an electronic file, I don't do this, it would go back to that particular email. But any indication that I was involved, I can tell you vehemently I was not. And then I can tell you as it relates to a type name that I did not sign, I do not type my name as Dexter Q Bond.
But I see your name in the bottom, and and it says Junior. Wasn't me.
So you've never seen this document?
I did not say that. I told you counsel has provided me the document.
That's what I meant before that. Have you ever seen it before council
I
provided?
don't, no, I haven't seen that. Because it appears, based on what you said, it was submitted to the state and it's submitted electronically. So that's what it appears. But again, I don't sign it. And what I do know, based on research, and as you know, that in three different of these state filings were filed by different employees, none of whom are me.
I'd like to ask a clarification question. So it says Deputy District Attorney Operations Division, and I think I understood your title is Deputy District Attorney of Operations. Is that right?
Yes, that's right.
Okay. So even though you might not have done it,
Someone's done it.
is it the job of the Operations Division of the District Attorney's Office to do these reports?
So I don't know. Let me
Okay.
explain.
Mhm.
I was presented with three.
Mhm.
The first one was done by a game unit. The second one was done by a forfeiture unit. This one was done by, well, I don't know who it was done by, but my name was on it.
Okay.
So
Did you approve
let's be
it?
very clear. I would not say, based on what you
Have you ever
provided
seen this
counsel,
before?
1, 2, and 3, and based on
Good.
who in my office did this state electronic input, and it needs to be clear that some of those people are no longer in the office, so I cannot verify, but I don't know.
So is it fair to say that this document does exist within your office?
I would say yes. But it's also fair to say that this document is in response to your open records request.
So it does exist. Did you do anything to search for this document?
Not this particular document, no. Why? Because you asked for documents filed with the county. I called the county. I got the equitable sharing agreement. The equitable sharing agreement deals with the substance of your request. I gave you that free of charge, and I sent it to you on January 26th in the email. So no, I did not do anything looking for the state, because you did not ask for the state. You asked for the local government authority, Fulton County. That's what I did, and that's what the Open Records Act requires.
And just to be clear, my request was what the county you had to actually do, what the law actually required.
That's not what your request is.
We can pull my.
Hey, the request is what the request is. Again, I can read, and I've seen the request multiple times.
Yes. So, if you had sent an email out asking for documents that the county required to be filed, would you have gotten this in response?
If you asked me a hypothetical, if I would have did what, I would have got what?
Research for this document. I'm trying to figure out, and I don't know, you gotta understand, I don't know how the DA maintains documents. These are documents that have to be maintained. So if you had done a search for it, or you had asked people for it, would you have been able to obtain this document?
Objection, Your Honor. This question has been asked over and over and answered over and over. I would like to move on. We can, please.
Actually, I disagree with you. I think this is actually a new question,
Oh,
which is where would this document exist if you had searched for it? Would you have found it? And that is a different question than whether he created it or was involved in its
I
creation.
misheard the question. I'm
That's
sorry.
okay. Thank you.
If I received the open records request looking for this, yes, I would have been able to go to a forfeiture deputy or a gang based on how it was filed in the past. But again, this record is not responsive to your open records request.
Do you, as a matter of practice, as the open records officer, do you use email to request open records?
It depends.
So it's not a general practice?
It depends on what you're asking for. If it's something, again, if it's something for a standard invoice, like you have sent to me several times, on staff meeting, I would say, hey, make sure you get this, put this in the portal. So I cannot tell you, it depends on what you're looking for.
So you sometimes do it oral?
Yeah, sometimes I do it orally, sometimes I do it, yeah.
If you sent emails asking for it, would you have those?
If I send emails asking for it, what is it? What are you talking about?
The records requests?
Yes, if I would have sent email, but sometimes I would have, the emails would exist, if that's your question. Sometimes I would say orally, sometimes I have my, someone else, hey, shoot this email to so-and-so to make sure, call so-and-so. So I don't, without you being specific, it's hard for me to answer your question because with 1,000 open records requests, there's no one set way onto how to meet my constituents' needs.
And I asked if you use email to request records, and then I asked if you did, you said sometimes, or depends. If you did use email, my question is, would you have those emails and know exactly what you asked for?
If I, Dexter Bond, sent the email, yes, the email will be on the on my email, my archive, my system.
And so you could provide that to the court so that we would know exactly what you did in response to this request, right?
These requests, you're starting general, then you're getting specific. I cannot follow your question, so I don't know. I told you several times, I don't know what I did on this specific request. You're taking what me saying general, and then you're saying, oh, well, you did do these. That's a correlation that you can't make, ma'am.
My question again was if you used emails.
If I did do
For
email
record requests.
for a specific record request,
If you used emails for a record request, we would be able to get those and see those, correct?
you will be able to request those, and yes, they will be there. If you're asking, do I delete emails, the answer is no. So yes, they're there. If I send an email, my emails are there.
I don't think he's going to finish today.
Did you ask for any of these specific documents that we've talked about here today by email?
We talked about a lot of different documents, so it's going to be very difficult for me to say yes or no. Okay? We talked about the equitable sharing agreement specifically. I told you that there was no, I don't know if I sent the email. I told you that. So the framing of your question doesn't allow me to answer.
Did you ask for any of these specific documents that we've discussed today by email?
As it relates to critical mention,
Did you ask for any of the documents we discussed today by email?
maybe. I don't know.
Is your use of the phone or in person to request documents on purpose?
On purpose?
Yes.
I don't understand your question. What you mean on purpose?
Do you purposely ask for things orally or in person? Do that
No.
on purpose?
Do I do that on, I don't, no. And no, the answer is no. That I don't do anything on purpose.
Have you been instructed not to put things in writing by email?
No.
Have you been instructed not to put things in writing, period?
By whom? No.
I've been streaming for 7
No.
hours today, Anna.
What is the office policy on the use of email and putting things in writing?
I don't understand the question.
Objection, Your Honor. So I'm trying to determine what the relevance is in terms of emails and the protocol for emails in the district attorney's office. What is the relevance here?
I think there's a tiny universe of requesting open records documents for purposes of his compliance. So I'm going to sustain your objection partially and ask you to reframe that question because I don't know that the general policy of the DA's office regarding email is relevant here. But Mr. Bond's understanding of any policy regarding Open Records Act requests by email is relevant. Go ahead.
Does the Open Records Act requirements or, disclosure, does that guide yours or your office's policy on putting things in writing?
Does the Open Records Act guide you? The answer is, I don't understand your question. Does the Open Records Act guide my, I don't even know if there's a policy. So you're making an inference that I cannot, you're assuming a premise there, right? And then you're asking a question. You need to simplify your question. What are you asking me? Because you're asking me, does the Open Records Act influence your policy? You have yet to ask me, is there a policy? What are you asking? Ask me what you're asking. That's a convoluted question that I can't answer.
I first asked you, what is the policy on the use of email?
For open records requests.
Yes. For open records requests.
The policy for email, use your email, and there's no policy. Look at the employee manual. You gave it to me. I don't know where you're getting at. I'm not familiar with the specific policy on use your emails this way because of open records. If you draw a correlation to two, forgive me, I don't understand. But there's no policy on emails as it relates to the Open Records Act. There are two entities that are different. So educate me on the correlation.
Educating correlation. What? What? What does that even mean?
I had just asked you if there was a policy.
What the hell does that even
So I
mean?
think that's the first step. If there's any policy on the use of emails in regards to the Open Records Act, not to put things in writing.
And I answered that question.
If there's no policy, is that your answer?
Yeah,
Because I didn't get it, and I'm sorry, but, I mean,
okay.
you asked me to rephrase it and it said it was confusing, but.
It's still confusing because you're rephrasing it the same way. What I'm telling you is there is no policy as it relates to emails as it relates to Open Records Act, right? Do you want to talk about take Open Records Act? Do you want to talk individually? What are you asking? But I'm answering your question as it's being framed. It's being framed poorly, so you're getting a poor answer.
What a dick. What a schmuck. I keep saying she needs to take control of this.
Can we take just a couple minutes?
Very couple of minutes.
Okay.
Are we need still a couple more minutes. We're only 3 minutes behind. It's 4:57. Oh, finally, a little bit of a break. And this is what I've been saying the whole time. What I've been saying the whole time is she's got to be controlling him better. And part of the way she does that, she could do that, is if she kept her questions all to like 15 words or less. Just short fact questions. Short fact questions. And it doesn't have to be 15 words or less, but the point is it's just like one little nugget per question, as opposed to like this whole big rigmarole setting things up with like this whole soliloquy before she gets to like her question. And again, I have a great deal of respect for her as an attorney. I think that she has a lot of skills in a lot of different areas, but there's so many different facets to being an effective attorney, and this area is her weakness, in my opinion. And we saw this at the evidentiary hearing back with FANI. It's just she's not as good at it. And when you have a difficult witness, is when it's really most glaring.
In response to the subpoena to come here today, did you search for any emails?
Okay. Did I search? I sent your search terms because your subpoena to me was asked for to and from emails. It gave search terms. I believe there was 2 search terms, critical mention and social media monitoring. So what I did do was fill out a ticket, as I do with most requests. I sent that over to the IT department based on what you're seeking. Were there any responsive documents?
Hold on, so if you need to request something from IT, you fill out a ticket for that?
If you give me search terms, so there's 2 different ways, right?
Okay.
So let's say you're looking for documents. And if your document is, hey, give me anything for critical mention, I can then do, hey, do you have these emails? Does this make sense? That's one way to do it, right? Your open records request originally, don't need to belabor the point, didn't answer that. Your second subpoena was very specific. It was this date to that date. From this email to this email. Here are the search terms. I need these search terms. I can then do a particular ticket or my staff can do a particular ticket, do it to CIO, the technology department. The technology department can run all emails. And then when they do all emails, they can come and say, hey, based on these search terms and based on my word ticket, here are responsive documents.
Okay. So if you had asked IT for any of our open records items before, there'd be some ticket for that.
There will be some form, some Excel sheet, some requests.
And you didn't bring any of those here today.
Did you ask for them? No, I don't.
But
As
you-
I shouldn't have. Why would-
But you would, those would be available. If you had asked IT for any documents, there would be a record.
I'm not the custodian of the IT records. I cannot speak for IT department, so I cannot answer that question because of speculation.
Okay, let's just walk through the subpoena quickly. I asked for all text messages sent by or received from employees. What did you do in response to that?
That's an IT question. We needed to figure out what the policy was as it relates to text messages, so I would fill out, hey, IT, this is what I'm looking for.
Did you do that in regards to the subpoena? We're talking about the subpoena for you to bring documents today.
I think the same thing.
The subpoena that, yes, and I gave you, hold on, let's be very clear. You asked for, you did not give me no subpoena to bring
And yes,
documents
he
today.
is.
Let's clear up
He
the
is
record.
filibuster.
What you did was you gave me a subpoena on August 21st to produce records, right? Those records were produced on August 30th. So there is no requirement for me to bring anything today. And I gave you those documents through my counsel on August 30th. So let's clear up the record. There's no requirement of me to do anything.
Talking about the subpoena for you to appear today. The subpoena for you to appear today had an exhibit that asked for emails and text messages sent by or received from in regards to critical mention. I'm asking you.
I need to
what
see
you
the
did-
subpoena. I don't
Hang
know
on,
what you're
hang on,
talking
let
about.
her, I understand, but let her finish her question. Y'all can't talk over each other.
I'm asking what you did in response to that.
I hear you. I don't know what subpoena you're referring to. What I am telling you is I got a subpoena that was for the production of records for August, and I gave it to you on August 30th. That's what I'm familiar with, so I can speak to that. If you're speaking of a different subpoena, you can hand it to me and I can review it.
You learned about court here today, correct?
Massive.
Somehow. You need to be here.
So are you not going, okay, different question. Somehow I knew to be here. Yes, my counsel told me that I needed to be here.
And you received a subpoena to be here today, whether it be through email or you signed a certificate.
No, I did not.
You didn't get an email with a.
You probably gave me an email. You probably gave me an email.
So then you did get it.
So
I'm pretty sure you gave me an email.
I'm sorry?
I'm pretty sure you emailed me. Yeah.
And attached to that email, there was a subpoena that included the production of documents, correct?
What subpoena are you talking about? There are multiple subpoenas. I've asked you several times, can I see the subpoena you're referring to? If you're talking about the one to me on August 21st, I can respond and tell you what I did. You are asking about a different subpoena, I need to be educated. I'm asking, I don't know what you're talking about, so I cannot respond. Are you willing to present to me something?
Of course, and I'm certainly not trying to hide anything. I'm trying to ask questions before.
I hear you, and I'm certainly trying to be very, very truthful to the court and clear up the record. In order for me to do it, because there have been multiple subpoenas, all I'm asking for, if I am under subpoena, and as you allege that I was supposed to bring something today, that's the allegation that you made among many, I would like to see it. That's all I'm saying.
Judge, his counsel's already talked about that, and I was understanding that he waived any issues with the subpoena to be here today. If that's not the case, I mean, I'm happy to show it to him, but without that, without him here.
I mean, so, okay, first of all, it's 4:59. So I need to check in with the court reporter who said she had a hard push at 5 o'clock. Now, I don't wish to interrupt in the middle of questioning when it looks like you were trying to get to a point of being done with the witness. But as you can see, my screen's starting to drop off. That's an indicator that my Zoom's about to die. So that's an indicator that we should adjourn. Separately, I will say, I agree with you. I think that Ms. Alabi agreed to produce Mr. Bond. That's a different question, though, than whether he received and was aware of the document request. So we'll just leave it at that for now.
And that's fine, I'm happy to answer those, but I know he was sequestered and didn't know what his
Right.
counsel had agreed to.
Sorry, I can't hear Ms. Merchant.
I know that he wasn't present and didn't know what his attorney had agreed to. And so I just, before we went down that road, I didn't know if he knew that they had agreed that he was here and subpoenaed.
Well, can I respond now?
You may, and then we're going to adjourn because I have to let the court reporter get on with her day since she's filling in.
I'm so sorry. This is definitely important. No, I'm glad I asked. I did not receive a September 13th subpoena. And let me clarify, because you need to know this. The subpoenas that you referred to, my name is not even on Exhibit A. So this is the first time, as I sit here today, that you have given me a subpoena that you said that I was responsible for. So no, I did not get this. It does not say when it was delivered. I have not received anything, and I don't know what was mailed. So no, I did not get this, and I'm not responsible for it.
Okay, and Judge, we've already put in the record the, when it was delivered, and I can put the email in where it was served. I'm happy to print that out tonight, and then we can question tomorrow.
So why am I not on Exhibit A? Something's wrong with that subpoena. Something's wrong with that subpoena.
Sir, that's a legal argument that your counsel can make. We've had some discussions this morning before you were called in to testify. And so
For 3 hours.
we can have that conversation tomorrow. But it is 5:02. The court reporter did everybody a favor by rearranging her schedule to stay for an extra hour. I assume we have on board a court reporter for tomorrow. For now, I'm going to excuse Mr. Bond, if he would step outside.
Come back tomorrow morning.
Mr. Bond, just reminder, Mr. Bond, that you're still testifying. And so you're still sequestered, right, regarding the substance of the hearing. And I'll need you to return tomorrow. I'm going to discuss with these lawyers in just a moment about what time I'll need you back. But just a reminder, okay?
Yes, ma'am.
Thank you, sir.
And not to review any of the, stuff today.
Well, I reminded him of his obligation under the rule of sequestration. So he's a lawyer, as I understand.
No,
it, so
Mr. Bond, I
he
expect you to
understands.
lie. Oh, there we go. Oh, geez. Oh, that was a hard out there by Channel 11. Oh, Lord. Oh, Lord. Well, there you go. So it seems like we're going to be back tomorrow morning. I will be streaming this tomorrow morning. I'm going to see if I can find anything else here real quick, which is still streaming the last parts here, conversations between the different counsel. Nope, that's not having it. Let's see if I can find it anywhere here. Okay, that's not having it.
Okay.
Thank you.
Thank you. Have a good day. We'll see everyone.
Yeah. Let's go back 5 minutes.
Time, as I sit here today, that you have given me a subpoena that you said that I was received on Exhibit A.
Oh, thanks. Mr. Moment about not he understands it. Okay, so I have a meeting at 8:30 in the morning, and then after that I can be available. So yeah, so 9:30. When do we want to get started?
So,
10.
I think Mr. Bond probably needs to know.
Well, I understand, but to the extent that we might need to have any substantive conversations, I thought it best to excuse Mr. Bond and his either defendant counsel or Miss. I had her name correct, and then you said it wrong, and so now is it Alabi?
Alabi.
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 I'm so sorry, ma'am. And either you, Miss Monroe, or Miss Alabi could advise Mr. Bond of the time.
What time?
So if it pleases the court, 10 o'clock, because I have drop off duties. for
Pleases
my children
Joe.
That I had to make accommodations for this
Pleases
morning.
Joe.
So 10 o'clock is available.
Any objection? I know you have a hard stop at 2 o'clock, but I believe there was some,
Side hospital at 2.
right, but there's some discussion that Mr. Merchant could carry on in your absence.
Yes, as long as that's okay, the split.
Well, hopefully, hopefully we will not come to that, but based on today, it might. Yes, ma'am. Did you have anything you wanted to add? Ms. Monroe requested 10 to accommodate, unplanned hearing in light of, childcare and other life issues. Just to be clear, I do want to make sure Ms. Merchant makes a valid point, which is that if she is in the middle of examining a witness and she needs to leave, there's not going to be an objection to Mr. Merchant taking over the examination of that witness. because otherwise we'll just need to make sure that we stop at 12:30 or 1 o'clock. And then I guess we will restart on Monday. I think I can be back here by 1 o'clock. So basically, this case is just going to go until we're done.
Wow. There you
We
go.
might have to take a few breaks here and there. So I
We're
have
gonna
a
keep going.
very large, I have pretrial motions and a gang murder case. So we'll figure out how to make it all work.
Lord.
Your Honor, I'm just checking to see if I'm available on Monday. I have a set of mediations that I just need to confirm if Monday is even an option for me.
So a couple of things to keep in mind. Number one, this is already a proceeding
Yes.
in process. And so I think I win all the conflict arguments. And number two, one way to avoid that, assuming that we can get to the end of this, is to simply
I just checked the calendar. We're good.
allow Ms. Merchant to leave and Mr. Merchant to take over should that occur.
How bad must he
Yeah,
be
we're,
that she's
Monday
the one
I'm
who keeps
open and Friday
questioning?
I'm also open.
We can start tomorrow night. It's.
Well, in an accommodation to
No.
Ms. Monroe, we're
No.
not going to start until 10 because
Because Joe won't.
she already made other arrangements today and I don't want to make her have to do it 2 days in a row. Okay?
I hadn't caught that.
Yes. Okay. Ms. Brown, I think we are adjourned for the day. Do you need anything else from me?
Just a quick question. Ms. Merchant, are we sharing in takedown?
No,
Okay.
we have not. We've tried very hard to minimize costs as much as humanly possible. Very hard.
And then
Okay.
I just want to make sure, I think Miss Monroe was who scheduled through us this morning.
Yes.
Were you in need of our services tomorrow or are we just filling in?
Tomorrow as well, please.
Okay, I'll reach out to my office. I will have them get in touch with you shortly, okay?
Yes, my paralegal's already on it, but that would be great if we guys both coordinate.
Okay. And that
Okay.
is me. Thank you.
Thank you. Have a good day. We'll see everyone.
All right, there you go. Tomorrow morning at 10, I will be back here, God willing. My plan is to be here at 10, keep streaming this thing on through. I think they're going from 10 till 2 tomorrow, and then resuming on Monday, perhaps Monday afternoon, like at 1 o'clock or so. So yeah, this is eventually we actually might get to FANI if we can work our way enough up the ladder. If you're Ashley Merchant, what you're basically looking to do is you're trying to establish that there was this was a coordinated effort for them to be basically jackasses to her and not provide her with the information that she was requesting. Now, those of you who are confused about what this whole hearing has been about, what the whole story is, I'll give you a quick synopsis here. Back in when these issues arose at the end of last year, early this year, so regarding Nathan Wade and Fannie Willis, Ashley Merchant, who's the one who really was the bulldog who was going after this, and that is her specialty. She's really aggressive as far as doing research and digging and things of that nature. And she's really good at making legal arguments as well. Her writing is fairly strong too. My biggest issue with her is the way she questions witnesses is very frustrating and almost just, it's just bouncing around too much and not reeling people in. And I do plan on having a show tonight. Yes, I have to find a topic, but yeah, I do plan on having a show tonight, as of right now, at least. So, and I'll be back here tomorrow morning at 10. But the objective here, so she submitted open requests pursuant to open records of Fulton County and the Fulton County District Attorney. Those are two distinct offices. She made requests of both. And she basically got a whole fat load of nothing and then evidence that there was things there. So she subpoenaed a number of people, including Fannie Willis. The judge came out and it's like, look, and the state and the district attorney's office came out and said, we're bringing a motion to quash that you shouldn't be able to bring any of these people. And they ended up conceding on allowing her to question Dexter Bond and also another woman. This woman here, Shalanda Miller, who's listed as this is Shalanda Miller. who is the official custodian of records. So that those are two people who the district attorney has allowed to answer questions. And what Bond basically, his perspective is, well, I gave you what you asked and you weren't specific enough, and I sometimes misunderstood you. And so either he misunderstood and basically gave her a lot of crap, very little responses. After she made these requests, they gave her nothing, so she brought her own private civil action. So that's what this is. It started in the criminal case, the RICO case, involving Donald Trump and her client, Mike Roman, where she was trying to establish all of the different nefarious activities of Fani Willis. And then she made open records. And then when they didn't want to respond to that, she made open records. She's like, you have to give me this, even if I wasn't an attorney. Even if this wasn't my case, you have to give it to me because it's Fulton County records. And under the Open Records Act, I'm entitled to get this. So she made all these different requests to Fulton County and to the Fulton County District Attorney's Office. And they really stonewalled her. And this guy here was a complete and total dick. The way he spoke, he even was like, I don't like you. You made 40 requests to me, which she claims is like, I made 12 requests in my life of Fani Willis, not 40, which 12 sounds like a lot. And it also sounds like a lot less than 40. It's a lot more reasonable. Because the reason they're trying to say that is because they're trying to say how she's purposefully harassing them. And the judge has been very, very intelligent, insightful, and to my mind, reasonable. I happen to like the work she's done from what we've seen of her today. She's like, look, you want to subpoena Fani Willis. You don't start with the CEO. That's not where we start. You may get there, that eventually I'll see that you're entitled to get it. They're trying to quash a subpoena that you can bring her to the stand. If you're trying to say, why didn't I get these records? She's not the one overseeing the records. So you can see, she's like, I could see a set of circumstances where her testimony might be relevant, but we're a long way from establishing that. So she basically ended up coming in with all the other people who were being subpoenaed. And some of the subpoenas related to different attorneys who were working there, part of Fani's PR team, and that Ashley Merchant is trying to establish that Fani Willis' interest in trying to protect her own PR has hired various media monitoring agencies to help her maintain a healthy PR. That does not seem like it should be a Fulton County expense. And yet it seems as if that's perhaps what she's been spending the taxpayers' money on, which is ridiculous to be spending on to help her maintain an image. Why the hell would that be part of their expense? And that's part of what Ashley seems to be trying to dig into. And while you could see how that might not be relevant necessarily in the criminal case, she's entitled, it may or may not prove to be relevant, who knows, but she's entitled to get it as a taxpayer of Fulton County. So this guy, Dexter Bond, is like, I don't like you. So, you ask me stuff that I don't really understand, or the way I'm interpreting it, it doesn't seem like we have it. So, F you. And if he's acting reasonably as far as his interpretations, so in that case, even if he's being a jerk about it, there's no law that he can't be a jerk, provided he's complying with his responsibilities and something that someone would consider reasonable. Now, I don't think that he's the ultimate target here. I think she does want to get Fani Willis to the stand, and part of that means she's got to work her way up the chain. And in that sense, I think Ashley has been somewhat successful in that, one of Fani Willis's right-hand people is this individual named Jeff DeSantis, who's the head of her PR or public relations of at least the district county attorney's office. And it seems as if he, and this guy here was like, I don't know if he has a court-appointed cell phone or not, the way all attorneys are supposed to. The only one who would have the answer to that would be Jeff DeSantis. And Jeff DeSantis is someone that Ashley has subpoenaed, that the attorneys for the defense were like, we don't want him to have to come in here. Well, based on Dexter Bond's testimony, I anticipate that this judge is going to say, well, how else are we going to get this information if he doesn't come in and appear? Give me 1 second. I'm getting an important phone call. Hold on 1 second. I'm wrapping up a stream here. Okay, give me 1 second.
Sure.
So so that's where we're at now. It's been frustrating watching Ashley Merchant try to ask these questions. Like I said, this is just not the area that she's best at. Perhaps her husband is better at. I don't know. Perhaps we'll see Ashley Merchant take the stand because she's obviously a very relevant party here. She's the one who made all these requests. And the nature of the request and the response that she got is part of the evidence. And you would imagine that her husband would be the one who would be questioning her rather than her getting up there. And without someone questioning her, it just flows better when someone's asking you questions and setting you up. So she may take the stand. I thought she might be the first witness to take the stand. I don't know. I don't know how that's going to play out. It's a little bit weird when you're taking the stand and also in one capacity and then asking questions as attorney in another capacity. But so tomorrow, the setup is this. We come back to court tonight. I'm going to be live streaming, not related to this likely. It's unlikely to be related to this. It's probably going to be about other news that's been happening in the world. And tomorrow morning at 10 a.m. is when we resume with Dexter Bond getting back on the stand, Ashley finishing her question, and then cross-examination and potential redirect. And then we're also going to hear from Shalonda Miller. And at that point, the judge is going to have to decide, do I have reasons to start looking into these other individuals who subpoenaed? And I expect that certainly with Jeff DeSantis at this point, you would think there's a good chance she will find that. The 5 other people or so that she asked for is kind of a wait and see. So Ashley Merchant is sort of working her way through the chain to try and get established that there's a need for them. And she seems to be doing fairly okay at that, even though it feels like pulling teeth, both from the witness end and from the way she's asking questions. It's just, you should get there a lot faster if she was asking short, fact-based questions. And the judge intelligently is even trying to push her in that direction. He's yelling at her, she's yelling at him with patience, but just sort of like, come on. So that's the story here. We will, if you're interested in following me on this, I'll be back here tomorrow at 10 a.m. You need to follow me at goodlogic.locals.com where you can get links for where I'm streaming at night. And I ask you, please like and subscribe, share this out with people so that they're interested in following along with this. And ultimately, we may see Fani Willis take the stand if Ashley Merchant gets her way and can establish that she put her thumb on the scale as to how these responses were given and whether potentially there's other information that Fani is having her cohorts in the office withhold from the public, which would be obviously a fascinating thing to see happening here. Any interested in Tim Pool versus Harris for president filing? A little bit, yeah. Perhaps if you can get that to me, I'd appreciate that. Send that over to me by DM. The last super chat here is don't forget to buy your mandatory pager beepers, stickers, armpit patches option. That's great. That's really great. That's really good. Let me take a quick check, make sure I didn't miss any rants here while I'm doing this. So I really need to take a nap. I have to find a way to take a nap and make a show. And then there's Thursday Night Football. I don't even know. All right. I think I'm good there. Quick check on locals. Okay, I'm good on locals. I'm gonna wrap up the stream here, and I expect to see you hopefully tonight. And check links, goodlogic.locals.com, and I will see you all then. Take care. Have a great day, and Godspeed.